mentioned on only unlisted. I will take all the mentioning extension of interim order or whatever it is. Give to my
matter has come up as the last
I will
item.
not hear anything.
But the last date of submission of tender is today, my lord.
What is? Ah. Ah.
Dada?
Madam, videos.
For what? Huh? Ah. Go right to the authority.
Well, last date for submission of tender today, I mentioned last Monday, your lordship kept it.
Already started from 16. Now in the mid I will.
Well,
That time I am mentioning, my lord. Regarding SIR.
no, not
Your lordship.
Maybe you are performing the duty as a teacher. You are drawing the salary. So
Your lordship.
well, last date for submission of the tender today. But I mentioned last week, your lordship kept it today. It's appearing as the last item. The last date of submission of tender is today, my lord. But if your lordship kindly permits, my
not
lord.
understanding. You are attending your duty. You are drawing your salary. For the only census duty, you are suffering from the high BP and diabetic. Huh? I already fixed the guidelines with regard to the census matter. The authority will take care of it.
Your lordship
Well,
for
Nothing else.
no.
Oh, give the voluntary or voluntary.
My lord, kindly do not take me amiss, my lord. I would have otherwise kindly do not take me. I would have otherwise given the slip. I had mentioned on 17th. Your lordship kept it today because the last date of the tender is today. But it's appearing as the last item, my lord.
What light? No, last item.
238, 228, my lord. My lord, because the last date is today, my lord. Your lordship kept it today, my lord.
आज रखा था तो 220 में कैसे चला गया? When it was taken up.
17th, your lordship was pleased to, my lord. I had given this order where this one paragraph was troubling us. Kindly sees the second page. Your lordship had appreciated this. And I've been permitted to participate in the tender, but that is subject to, my lord, that is why, my lord, we are being prevented. They are saying you can participate, but the fate you know. But your lordship had seen this, my lord, on last Monday and kept it today, my lord. And I have all the list. I'm mentioning upon not all the list of the tenders which are there. Your lordship would find the last date today, my lord. Coal India and its subsidiaries, my lord. And I've been permitted to participate, but that paragraph is really what is, my lord.
This is 2023. Not
Well, it can be because of the new tenders which has come up. I can participate, but they said that you know your fate because of the pendency of the writ petition and this paragraph. So only clarification my can. Nothing else. The writ petition can be heard at a later time. Only my can for the clarification. Nothing else.
What clarification you want?
That this from accept in accordance with law.
No, if it is a new tender or continuous.
New tender.
So new tender.
I can participate. Kindly says the previous paragraph. I have been given leave to participate. But
so
they said that you know your fate because of the writ petition being pending. So because of that paragraph. But and all the tenders, Coal India and subsidiaries, I'm losing out on everything. I'm carrying all the this would show last date today. I have missed a few also in the meantime, but kindly permits, my lord.
My lord,
I'm so grateful.
My lord.
It mentioned upon.
It has already allowed.
I already stated
this is an
all the mentioning list.
My lord.
Unlisted writ petition, lordship. It's an unlisted writ petition, my lord. I'm very short matter, my lord. I'm praying for anonymization of my name, my lord.
My lord, this matter, my lord has already allowed to be listed on within first 15 on 14 July. But it was listed on 42. My lord, then my lord gradually has gone down and went, my lord, to the monthly list. My lord, it is a matter, my lord, that a poor lady, my lord, running his business, it has been closed. My lord, that running is, my lord, running his business. But that due to that, my lord, illegal, my lord, complaint without any unverified complaint, my lord, bank account has been freezed. I'm suffering, my lord. I went to even
There
Gujarat.
are several cases of bank freezing of the bank
Any
account.
small matter, my lord, I shall not take more than 5.
If I will take the bank account, freezer of bank account as an interim measure, then I have to, the whole day, the court has to take the bank matters on.
No, my lord, that
Then-
my lord already allowed once.
Somebody's,
My lord was
somebody's
pleased to
running the
Wait a minute.
business, somebody's saving account has been closed, somebody's,
My
the
lord, kindly seize the
salary account is
incident. My
closed.
lord, kindly seize the incident, my lord. That that I am unable to pay my staff.
Okay, give in writing.
My lord, I have a very short
My
prayer,
lord,
lordship.
any
My lord,
form, my lord already allowed me.
Yeah, though, yeah.
My
My lord, kindly,
my
my
lord,
lord, it is an unlisted matter, my lord.
kindly, my lord.
यहाँ दो बोलने से वहां क्यों देते हो की देखाচ্ছিলে फिक्स मैडम आइटम 40 से तुम लोग पीछे क्यों कर देते हैं हाँ तो फिर वो 70 में कैसे चला जाता
14 July.
डे आफ्टर रखो
Grateful, my lord. Most.
Lordship, this is,
give the urgency list give the urgency list
Kindly. Tomorrow.
yes call the list
attorney now.
if any unlisted motion I will take
Unlisted, unlisted.
give all the
My lord, one unlisted motion, my lord. My lord, the petitioner has qualified NEET exam, my lord.
give the mentioning list
My lord,
unlisted I don't know
my lord, this is. My lord, the petitioner has qualified a NEET examination, my lord. I have already mentioned it. It is already mentioned, Korachi.
I don't know. I did not find any urgency, sir. I find any urgency, I am allowing all the unlisted motion. I am allowing. You are working as a teacher. You are attending your school. You are drawing your salary. You are enjoying your summer vacation. Now the census, you are suffering from high BP and the diabetic. And 16th already the census is started. Now in the mid you are coming now. After 10 days. कल के रखो उसको टॉप में रखो I find I will not get any merit. The cost is to be imposed from the salary from the month of August, September. This may be remember. If I find I could not find the merit, you sell the cost will be recovered from your monthly salary. Kal tomorrow top, at the top issue notice.
My lord, my lord,
But remind it with the condition I am giving this.
my lord,
Unlisted,
Tomorrow top,
my lord,
or one
but issue notice.
my lord, on unlisted matter, my lord, the petitioner has qualified NEET examination matter as well as my lord WBJS, my lord, JE, my lord, kindly, I have already mentioned it, my lord.
You do one thing, come with the 4 laborers in the evening at 4:30, trace out all the files, I will list.
My lord, this is a fresh filing. my
That's
lord.
why I'm
Kindly
telling you come
kindly.
in the evening with 4 laborers. I will sit here in my presence, check the file. If you trace out the file, I will list tomorrow at the top in the SIR matter.
My lord, this is a grave urgency, my lord.
Then you are
That's- I have-
understanding? My staff is not able to trace out all the files of the SIR matters. Thousands pending. I have taken the another court for keeping the files.
my lord,
What can be done? You persons are filing and filing, then mentioning the matter. I am taking whatever the file is available, tracing out.
my lord, I'll then.
Yes, call the list.
or one unlisted matter, or one unlisted matter, if I just could take
Who is
it.
item number 1?
My lord, my lord, one unlisted matter, if I just could mention, my lord.
28?
My lord, one unlisted motion, my lord, about election. Lord, in the rifles factories, my lord. I'm sorry.
Issue notice.
But one rifles factories, my lord, election. If I just could mention one
Unlisted.
my lord, this, my lord.
Where is the unlisted?
my lord, it is filed, my lord, but it's
Yeah.
the election, my lord, the rifle factory. I would not have disturbed your lordship. The election, my lord, is if your lordship gives, my lord, 1 minute time in the matter, my lord, because the notification under which rule, my lord, there has been given, it is, my lord, but it is not there anymore in existence. So, my lord, now the election process is going to be held. The polling will be done in the rifle factory, my lord, on 28th.
Hmm.
Otherwise, I would not have come and disturbed your lordship.
So what you want?
My lord, if your lordship
How
takes
the
this,
court can
this,
enter
this
into the election process?
because, my lord, the election process, the rule by which, my lord, that has been introduced, the rule is not there in existence anymore.
Hmm.
It's an absurd, my lord, notification
Who has who has framed the rules?
my lord, the central government.
Then
It is not there in the my lord, force anymore. It is by the central government itself, my lord, that has been taken away. So if I just could get your lordship 30 seconds time, I'll just impress on your lordship. I'm so grateful to my lord. So grateful.
you're not understanding English. You're given the mention English. Yes. Who is item number one? Who is item number one? What is the correction? Somebody is mentioned. Where is the mentioning list? ঠিক তো আছে Century Infra Limited. Century Infra Limited. No, it's can you see Infra Limited? See. Infra Limited. You persons are not typing the cost title of the front page properly. Have you read petition? You have a read petition? Come to the first page, cost title. Index, where the index is, what is others? And come to your read petition cost title, another, record another. The matter is listed as to be mentioned receipt of the report from the department. It is found from the report that in the cost title, there are two plaintiffs and two petitioners, that is Century Infra Limited and Pawan Kumar Gupta. But in the cost title, but in the judgment dated, in the judgment dated 30th June 2026, in the cost title, the name of the petitioner is recorded as Century Infra Limited and others. Accordingly, in the judgment dated 30th June 2026, in the cost title, the name of the petitioner shall be read as Century Infra Limited and another instead of others. The department is directed to correct the cost title in the judgment dated 30th June 2026. Yes. Next. Yes.
I appear for the state.
Yes.
Report is to be submitted, my lord. This is the report. The report.
What is the matter?
by two cyber crime minors.
Hmm.
By form, talking minor and threatening activity.
Hmm.
Case is I mean, this really going on since 2020. Back then, when the petitioner was 19
Hmm.
and was not financially independent to continue. That's why the Indian filed.
Hmm.
Pilot, the petitioner was engaged in
Hmm.
and accused was approached to
Hmm.
impersonify as an agency of motive.
Hmm.
Pilot acquired certain pictures, stating that it would require for the selection of the modeling pilot.
Hmm.
And later on, when the accused person has demanded a
Hmm.
posture training video calling,
Hmm.
and the petitioner has denied.
Hmm.
And from that particular point of time, the blackmailing has started. The petitioner out of fear moved out of India to UK for higher studies so that the accused person cannot trace her.
Hmm.
But the accused person has stalked the petitioner, has acquired the UK address, the UK phone number, and where she was interning at that point of time. He acquired everything.
Hmm.
The petitioner later got to know that this is a mail. But firstly, he impersonified as.
So what you want?
My lord,
What is your prayer?
yes, my lord. The prayer is, my lord, in-depth investigation, and which has been withholding, which is why I have filed this writ petition. After the writ petition was filed, the inspector who was assigned this investigation contacted, but before that, when I filed the complaint, I filed the GT, I filed the FIR, no investigation was being carrying on by the said investigating officer.
Hmm.
The petitioner has tried to visit the police station several times, tried to contact the inspector of the police station, concerned inspector. No steps have been taken.
Hmm.
Now today, they have given a copy of the report, my lord.
Hmm.
My lord, where it was stating that the investigation is going on, my lord, they have tracked down the accused to mobile towers,
Hmm.
but no steps against that accused person has been taken till date.
Hmm.
Now the investigation will go on for illicit.
Hmm.
And also the links where the illicit pictures of the petitioner is still available and circulating in social media.
Hmm.
And they are not taking any steps for putting it down or blocking the said website or the said post.
Hmm. Okay, let they file the report, detailed report, what they're doing. Huh?
The blocking of the link,
Huh?
blocking of the link,
Huh.
or the link where the fake profile.
Huh.
Different fake profiles have been made, all the information has been given by the petitioner to the investigating officer.
Hmm.
Let them be taken down and the investigation must go on.
So where is the prayer?
My lord, I've made 3 prayers, my lord. My lord, A1, I have made in-depth investigation regarding Narendrapur.
That investigation is going on. How
Yes,
the
my
court
lord.
can interfere with that?
A2,
Hmm.
accused being private respondent number 7 hearing and sees the obscene photos and videos with the small.
Correct. So that's why let the report come, because now when it is February it was registered. What the investigators and producer?
Yes, yes, page 2 of the report. my lord.
No, producer CD. Why February? Now we are on August.
Yes, kindly.
Why?
That is why page 2,
why you
paragraph
have not
1 of
blocked
the report.
blocked
Kindly.
higher rates, sir.
Acha.
Let hear what the court is asking you.
My lord, I'm sorry.
Why the investigating officer has not blocked the obscene videos during investigation?
That is why I am referring the paragraph number 1, page 2.
Hmm.
Kindly, I am reading. my lord.
Yes.
Following this, the investigating officer sent a formal requisition to the inspector in charge of Cybercrime Police Station, Baripur Police District, previous GD number such and such, and requesting user details and technical inputs for the 2 social media links. In response, the Cybercrime Police Station identified the individual link to private respondent number 7 and traced a mobile number such and such used to log into the Instagram account, prompting the IO and seek the CAF, CDR, SDR and tower location details for the said number. The IC Cybercrime PS Baripur Police Station District also sent a prayer to the Facebook on 26 January for providing necessary details about the Facebook profile from which the photographs of the victim lady were uploaded. But the official reply from the Facebook platform is still awaited.
Correct.
Every action has been taken.
That's why when this request was made, February FIR was chalked out. When this request was made,
Request was made in January 26.
where from you are getting January 26 in the paragraph?
First paragraph. First paragraph of page 2.
Where is the January
Report.
26? Where you are getting January 26?
Yes.
Correct. FIR lodged.
No.
FIR lodged
If I lodged much prior.
much prior. See the FIR
GD,
date and
GD.
number.
Being the GD,
Sir, I am asking. See the FIR number and date.
11/11/25.
FIR number. FIR number.
FIR number I don't have in the report.
Not.
For that I have to take instruction, Milord.
Huh? So what report your IO has submitted here? If he has not.
No, on the basis of the GD.
Come to the writ petition. Come to the payer.
Yes.
What is the FIR number? What is the date? And in which he has submitted the report? That's why I'm asking the CD.
CD, if Lordship directs, I can
Kindly
put it.
comes the page 20 prayer A.
Yes.
11 preliminary inquiry you have conducted. January you send the letter.
Yeah.
February you registered an FIR.
Yes.
And you are giving the statement of November and January. What has happened after the FIR?
After the FIR, Milord, kindly comes to second paragraph of the page 2. Upon receiving the report from the Cybercrime Police Station, the investigating officer analyzed the technical data. While the sale detail CDR report was mostly blank, except for a single incoming message received on such and such date. That is, Milord, after
When you received the
4/5/25.
When you received the report?
The customer application from CAF details led to the identification of a suspected tower address location such and such.
With regard to the paragraph 2, when you received the report?
Which report, Milord?
Paragraph 2, just you read.
Yes.
Your officer received the report. When you received the report?
Single incoming message received on 4th May 2025.
4th May.
4th May.
And first paragraph 11/11/2025.
11/20/25.
So
because I am
investigating officer, your investigating officer, the Urdu medium teacher, Urdu medium student. Going back.
My lord, kindly appreciate for the technical details of cybercrime, it takes time, my lord. If lordship directs, I can
state has submitted a report, but the investigating officer has not stated with regard to the present status of the case. So from the repetition, it reveals that the police, from the report, it reveals that the police has started inquiry in the month of May 2025. But the FIR has been chalked out on 23rd of February 2026. Accordingly, the investigating officer is directed to be present along with the case diary, up to date on 2nd September 2026. This is the matter on 2nd September 2020 within 5 matters.
And kindly, one point, my lord. She is stating that the obscene photographs to be taken down from the social media account. For that, she has to make a party. Meta is not a party here. Instagram and Facebook is run by Meta. For that, she has to make them a party.
How many police cases you appeared? How many police cases you have appeared? If the case has been investigating by the police authority, whether the complainant is required to give every time this is to be done, this is to
As,
be done.
as writ petition is preferred, that is why
If your
data is a necessary
authority-
party.
If your authority is investigating the matter, the investigating officer has the duty to take all the precautions.
Yes,
So how you are telling that the matter will be
requisition sent to the meta,
Come
requisition
on
sent.
second, come on second with the CD. I will see to that. Who is there?
My lord.
Ma'am,
Yes.
in the department.
What is that?
My lord, may I?
Copy দেবেন না?
এটা একটু পরে দেবো, স্যার। কারণ পরে দিব।
দিয়েছেন এখন?
আমি দিয়ে দিচ্ছি, আমি দিয়ে যে সফট কপি আছে।
Yes.
My lord,
My lord, issue was my lord my photograph. They wanted to see me, your lordship has recorded,
that,
and ultimately no photograph was taken, my lord.
that was not the photograph issue, my
Your
lord.
lordship may dispose of the writ. Only one line I will request your lordship to add, my lord. They should be cautious in my lord.
My lord, there is no
Nothing more.
requirement of cautious, my lord, caution, my lord, because my lord, what we have done, my lord, as per the RBI guidelines, my lord, we can always do that. And my lord, our back-end system has sought for certain clarification. We had to do that. And my lord, we.
Okay, yeah.
May I just read
Yes,
out
my lord.
one paragraph, my lord. Your lordship's order, my lord, para 1, third
That was a
line, my lord, fourth
preliminary
line.
observation, my lord. That day I
No,
was not.
perfect. My lord, may I
Yes.
just read it out? My lord, this is the statement, my lord, of my dear friend recorded. It is further mentioned that the petitioner, my lord, has seen, my lord, para 1, fourth line of your lordship's order.
Yes.
It is further mentioned that the petitioner is not required to appear before the bank in person. The executive of the bank will visit such and such. If that was the requirement, my lord, that I was not required to go, then this exercise was not required, my lord, that they will block it. The regulations say that regulation, my lord, regulations say that
Okay.
first you issue notice then.
My lord, we have issued model.
Now you got your
My lord-
leave.
Your lordship will record my submission, lordship
My lord,
dispose it off.
may I allow to? My lord, this
Only
order
difficulty
was.
in future if it
My lord,
happens, my lord,
it
again.
can happen, my lord. In future, it can also happen. My lord, this is a. My lord,
Yes,
may
yes,
I?
what?
My lord, may I indicate, my lord, these order earlier. Will you allow me
No,
to
no,
submit
yes,
before
yes,
the
yes.
court, my lord? My lord, on 18th, earlier order was passed on in considering the order, email dated 18th August, my lord, which was sent by the branch office personal banker to relationship manager to the petitioner, my lord. My lord, there also we have not indicated that he need to personally. We have indicated that a KYC was a requirement. My lord,
Madam,
may I- now, my lord.
The thing is that if you are taking any action against, I am not telling about this petitioner.
My lord.
Any customers, you are taking any action against them, let first you inform that.
My lord,
so
that was
first it has to be cured.
My lord, that
They
was.
are not
That's the
coming within,
RBI guideline. my
if
lord.
it is not coming within 24 hours or 14 hours, whatever you
Exactly.
fix the timeline, then you can say,
My-
yes, they are avoiding the same. So you have blocked, you have no other option but to block.
My lord,
I am
kind-
not
My
in
lord-
regards to a particular person, a particular man. If I am asking, I am telling with regard to the general.
My lord, in general also, my lord, what I am submitting, this blocking has been made by the central team, my lord. There was a, my lord, I have already handed over your lordships, the details procedure, my lord. What is being followed, my lord? Third party data, that there was certain indication, my lord, they have system has blocked. Immediately a system generated information email, my lord, which is at their page 110, my lord, of their writ petition, that was generated, my lord. That was generated, my lord.
Well, kindly sees the RBI guidelines, my lord.
May I
B,
complete, my lord?
freezing and closure.
My lord, thereafter,
Always
my lord,
after notice, that too
Yes.
partial.
my lord, that thereafter, my lord, when the system generated notice,
Which provision you are relying upon?
My lord, B, if your lordship is freezing and closure of account, if I may place, in case of non-compliance of KOC requirement by the customers, despite repeated reminders by the bank may impose partial freezing on KYC non-compliance account in a phased manner. So it is always to be, my lord, followed up by the notice. Number 2, partial, my lord. That first debit, then the credit, my lord. Then, my lord, 2, 3, Roman 3, my lord. While imposing partial freezing, banks have to ensure that the option of partial freezing in exercise after giving due notice to 3 months initially to the customer to comply with KYC requirement to be followed up by a reminder giving a further period of 3 months. Then, my lord, fourth, thereafter the bank may impose partial freezing.
My lord, that was
So
the
it is
general, my
still
lord.
fasciculars provided, my lord, another guideline.
My lord,
Now,
that was the general, my
whoever
lord.
might be the authority, my lord, the central team, the other team, my lord, whatever my learned friend may say, all are bound by these RBI guidelines, my lord.
My lord, we have not violated, my lord. My lord, now my lord, may I hand over? This is the older guideline, my lord. My lord, there are certain 2010, my lord. My lord,
This is 2016,
yes,
what we have.
my lord, page number 2, my lord, paragraph number 2.3, my lord.
What is the date? 2010.
My lord, yes, my lord. But my lord, there was a KYC policy indicating, my lord, there was a customer
Which provision?
2.3, my lord.
Yes. Acceptance policy.
My lord, there are, my lord, now, my lord, subpara 3, my lord.
Hmm.
Document requirement and information to be collected in respect of different categories customers depending on perceived risks, keeping in mind requirements of PML Act 2002 and instruction guideline issued by the Reserve. My lord, this is
Documentation
yes.
requirements and other information to be collected in respect of the different category of depending on the perceived risk by keeping in mind the requirement of PML Act and the instructions guideline issued by the Reserve Bank from time to time.
My lord, now, my lord, what was my report? Now, my report was that, my lord, it was never, there was no intention to harass the petitioner, my lord. Only an additional KYC we have sought for, my lord. That is what I am submitting, my lord.
What
My lord,
you are relying
may I-
upon? Yeah. From this document, what you are relying upon?
My lord. My lord, kindly see, my lord.
The court
This is
and the
the-
court
yes,
and
my lord,
the
please can read.
the general public and the court will never be in a position to ascertain
My lord, that
regard to
is,
the writings of the bank and the
my lord, that
defense
is,
authority.
yes, my lord.
Absolutely.
My lord, that is what I am
And
submitting.
KOC, my lord, I don't, my lord, I never, my lord, join issue with KYC, my lord. But issue
My
is
lord,
that
now-
how do you block it, my lord? Just
My
the
lord,
reverse
there was
application, my
a temporary blocking, my lord.
Where
That's also blocking.
Yes,
My lord,
please.
Sorry.
My lord, in my, that is a back-end report, my lord. I also could not understand it is full. This is a search summary, my lord. My lord, kindly see the high risk factor. It was mentioned. That is a status report, my lord, high risk factor, my lord.
Which page?
My lord, in the first page, my lord, itself.
High risk factor.
Yes, my lord, include.
Yes.
And my lord, the cases are included, my lord. That was the summary report and system has automatically blocked. My lord, thereafter, immediately we took up the case, my lord. We have only requested him to, he could have easily said, my lord, to that kindly send someone to, my lord, accordingly, my lord, on 18th August, my lord, the email which we have written to him, my lord.
That was, my lord, after the matter was taken up by your lordship only.
Okay.
My lord, there was a regular communication.
So
my
what
lord.
you want?
My lord, I do not want
Want
it.
the guidelines by this court?
No, my lord, let it be disposed
Your
of, my
lordship may dispose it.
Yes,
Your lordship may record my concern, my lord, that it should not be, my lord,
My lord,
repeated.
then my submission also be recorded, my lord. This was never intent.
And
There was no intention.
if I may request for, my lord, a token cost, my lord, for the harassment.
My lord, there was no harassment, my lord. If it would have been an ordinary person.
I will.
No, but only, my lord, only what is egregious, my lord, the bank is not aware about the regulation, my lord.
We
They
were
say
aware.
that we don't know what is there, we just block it simply.
No, we have not said that. We have requested him to
Petitioner has
contact
filed
the
a
cluster
present
head also.
application praying for a mandamus directing the respondent number 426 to withdraw and set aside the suspension of the petitioner's bank account bearing number 501001746037764 maintained with the HDFC Bank, UN Brahmachari Street branch, as communicated to the petitioner by an electronic mail dated 10th August 2026. The matter was taken up for hearing on 20 August 2026. No, 20th August 2026. At the time of hearing of the said application, the bank has submitted a communication wherein it was informed to this court the petitioner is required to file KYC form, photo address proof, Aadhaar voter ID passport, driving license, and PAN card. It was also mentioned that the KYC is not permitted by online due to the blockage of the account of the petitioner. Accordingly, the petitioner has submitted all the documents to the bank authorities, and now bank authorities. Today, when the matter is called, the bank has submitted the report wherein it is informed that the account of the petitioner has been regularized and both debit card and credit card are active, and separate email communication has been sent to the petitioner regarding the activation of the debit card and credit card as well as the account.
My lord.
As well as account. Full stop. Then counsel for the petitioner submit that without any reason and without any notice to the petitioner, the bank has freezed the account of the petitioner with only to harass the petitioner. Then counsel for the bank has submit that the bank has not intentionally or arbitrarily blocked the account, as the bank has noticed the high risk factor on the account of the petitioner. Accordingly, the same was blocked. Consider the submission made by the counsel for the respective parties. This court find that the grievance of the petitioner to set aside and quashing of the communication wherein the account of the petitioner was freezed. Now the bank has already defreezed the account of the petitioner and the debit and credit card has been activated. Thus, this court find that no further order is required to pass. Accordingly, the petition is disposed of.
Grateful, ma'am. File contempt if I don't go. Grateful, my lord.
Assignment. Wala assignment. Under second September under the same heading. तो assignment अलग ही होता है. Yes, next.
I am opposing a note.
Cancellation of SC certificate can be done by the SGO.
Yes.
without deferring to screening. That's the whole issue.
Yes, sir. Have you taken instruction?
My lord.
Yes.
My lord, the total my lord, misconception of law. There are two mechanisms under the Act 9.1, 9.2. 9.1 is my lord, exercised by the SDO, the issuing authority, and 9.2 is my lord, the function of the committee, selection committee. Lord, this case is processed in under section 9.1. Notice of so-called issued in 9.1. 9.1 order is passed in 9.1. Now, my lord, selection committee has no role in the matter.
What is the difference between that two rules?
No, 9.1 is my lord, the proceeding by the SDO himself. On the receipt of the
Proceeding
complaint.
can be initiated, whether he can initiate the proceeding, inquire into the matter, but the report has to be submitted to the
No,
committee.
he can straightway cancel the license.
Where is the law? Show me the book.
Yes, my lord. Kindly see.
Show me the law that he can cancel it.
I mean, even the committee, my lord, after the recommendation committee, they have considered they have to send to SDO itself. Committee will not cancel the license, the certificate.
No, committee will approve, then the
in
cancellation order will be passed by the SDO.
In the proceeding of 9.2, not in 9.1.
Give, what is the law?
No, kindly see, my lord, this. Kindly see section 9.1 and 9.2, my lord. I have placed both the sections, which are very clear. First, my lord, I have placed the section 9.1.
9.1?
Yes, 9.1. If the certificate issuing authority, IMRA SDO, is satisfied that a certificate under this act has been obtained by any person by furnishing any false information or by misrepresenting any fact or by suppressing any material information or by producing any document which is an act of forgery, it may cancel, impound or revoke such certificate in such manner as may be prescribed. Now, prescription is the rule. I have placed to the rule. That is the rule 3, notice of so-called rule 4, 5, 6. That is 9.1, my lord. Here, my lord, kindly 9.2. Non-standing, so non-abstentive clause, non-standing, anything contained in subsection 1, if the committee is satisfied that a certificate under this act has been obtained by any person by furnishing any false information or by misrepresenting any fact or by suppressing any material informations or by producing any document is an act of forgery, it may issue a direction to the certificate issuing authority in such manner as may be prescribed to cancel, impound, or revoke such certificate, and on receipt of such direction of the certificate, the issuing authority shall, by order in writing, cancel, revoke the certificate. This is the lord. Second is lord by through the committee, and first is straight by the SDO, by the certificate officer. Now, my lord, this 9(1) and 9(2) is totally two mechanism. It has nothing to do with the,
Where is the prescribed law?
now my lord, I will, my lord, give this rule, my lord, kindly see this rule. Rule 3, 4, 5, my lord, I will place rule 3.
Rule 3.
3.
Yes.
Procedure for cancellation, impounding or revocation of certificate.
Yes.
Whenever it appears for a certificate issuing authority on complaint by any person or suo motu that a person in whose favor scheduled caste or scheduled tribe certificate has been issued does not belong to such caste or tribe, the certificate issuing authority shall hold a preliminary inquiry by itself or by any officer above the rank of inspector of the scheduled caste and scheduled tribe welfare department, as may be authorized by it on behalf, and shall prima facie satisfy itself to the truth or otherwise of the complaint as aforesaid, record the reasons of his satisfaction as to the truth or otherwise of the complaint, and if necessary, start proceeding for cancellation, impounding, or revocation of the certificate as the case may be. 2. Where any proceeding have been started under sub rule 1, the certificate issuing authority shall, by written notice, ask the person holding a certificate to deposit the same in original in its office, and when the certificate has been deposited, a receipt in favor of the person depositing shall be issued. 3. The certificate issuing authority shall then issue a notice to the holder of the certificate to so cause within 15 days or within a period of shorter duration as it thinks fit, as to why the certificate issued in this favor shall not be cancelled. Then note 4A. On the expiry of the period referred to in sub rule 3, the certificate or issuing authority shall fix the date of hearing of the case by notice to the complainant and holder of the certificate, asking them to bring oral evidence or documentary evidence or as the case may be in support of the caste certificate of the holder. Then Lord 4B, a copy of the notice issuing the complainant, if any, and the holder of the certificate shall be affixed to the notice board. Then Lord C, the service of any notice under these rules shall be governed by so and so. Then Lord sub rule 4, order of hearing, etc., to be in writing. Any order by the certificate or issuing authority for the purpose of hearing the witness giving evidence against or as the case may be in support of caste or the tribe, identity of the holder of the certificate or of such other person as it is necessary to hear or for the purpose of inspection of any document. Then Lord 5, cancellation. When the certificate issuing authority is satisfied that the person in whose favor the certificate was issued does not belong to the caste or as a tribe, as it may be, it shall by order cancel, impound or revoke the certificate and shall notify the cancellation, impounding or revocation to the person from the certificate was issued and also to the authority, if any, before which certificate was produced by the holder of certificate. Then publication in the order of the cancellation, impounding or revocation. A copy of the every order, cancellation, impounding or revocation of the certificate shall under rule 5 shall be forwarded to the state government by the certificate issuing authority for information of the public in such manner as state government may determine. Then law 7, certificate issuing authority to file complaint against any such person for furnishing a false, this is a criminal complaint. Now 7, now Lord A, 7A, recommending authority and authorized official in respect of rural area, the block development officer within whose territorial jurisdiction the applicant ordinarily resides shall be the recommending authority in urban area, excluding Calcutta. Such authority shall be the officer not below the rank of deputy magistrate as the case may be. So, now these are the then Lord 7B form of application. So these are pan election.
What about the 7A? 7A.
7A. No, 7A recommending authority to authorize.
Recommending authority.
No, this is after if it is cancelled, then it has to be recommended to the
Correct.
the cancellation.
That's why you can inquire it, you can do that, then it has to send to the authority, that is the district magistrate.
Now, after the cancellation.
After the cancellation, how the recommend?
Well, kindly see, the 7 is certificate issuing authority to file a complaint. He will file a complaint to the police. Then 7B, recommending authority and authorized official in respect of rural area. But this is not.
I pass one order. One judgment I pass relying upon the division bench order and one reported judgment is there.
Madhuri passing reported judgment.
But I have got a judgment, my lord, of the coordinate. Sorry.
Yes, sir.
I have got a judgment of the coordinate bench. Now against this order, which is under challenge, 29 July order, there is no allegation of violation of natural justice. Only violation is, there is no recommendation of the committee. That's the only ground. Now that order has been, there is no amendment of the act. This has been made applicable under section 9A. Section 9A, this order is applicable, passed by the SDO. Kindly see the date in 2022, 9A, it is provided. Appeal will lie to the so and so. The second, therefore, Lord, if there is alternative remedy, then Lord, no writ lies unless there is a ground of violation of natural justice.
Yes.
Now, Lord, I will not cite one
If-
judgment, it's very relevant.
If the court finds that the without jurisdiction, then whether it lie or not.
Yes, certainly. But there are my grounds, my Lord. I don't say, my Lord, the writ doesn't lie. The writ lies, but there should be ground. Here, my Lord, kindly see this judgment of the coordinate bench, but very thorough on the subject, which we said two different mechanism. No, there is, my Lord, in 9-1. May kindly come to my Lord. Paragraph 15 straightway. I will not take your lordship's time too much. Paragraph 15. Learned counsel appearing for the petition places reliance on an unreported judgment of this honorable court in Krishnapada Sarkar and another so and so with reference to the scrutiny committee is mandatory before cancelling a scheduled caste certificate. Learned counsel further relies on Kumari Madhuri Patil and others so and so reported in 94 so SEC, which lays down the procedure for issuance of social status certificate, their scrutiny and their approval, taking into account the verification of the caste certificate by the scrutiny committee. Then we'll kindly come to straight page, my Lord, 29.
Yes.
No, 29. That apart, the proposition on which I rely is Krishnapada Sarkar as regards to the reference of the matter to the State Scrutiny Committee in an inquiry under section 9, subsection 1 of the Act per incurium. A bare reading of the provision of section 9 of the said Act makes it clear that subsection 1 and 2 of the 9 are independent of each other in their sphere of operation. Section 9(1) contemplates cancellation or revocation of a certificate if the certificate issuing authority is satisfied that the same was obtained by furnishing any false information or by misrepresentation, any fact or suppression of any material information, or by producing any document which is an forgery. The procedure for such inquiry has laid down in detail in Rule 3 of the 1995 rules, I place it, which contemplates a preliminary inquiry, a subsequent hearing upon consideration of oral and documentary evidence upon notice, and a subsequent adjudication on the issue of subdivisional office under Rule 3(4)(c) provides that certificates of the notice under these rules shall be governed by provision of CPC. Then we'll kindly come to page para 31. 31 is relevant. Section 9, subsection 2, on the other hand, begins with the non-obstante clause, disassociating the said subsection from subsection 1 of 9. Under subsection 2, the State Scrutiny Committee, if satisfied on similar criteria as the SDO under 1, may issue a direction to the certificate issuing authority to cancel, impound, or revoke such certificate, upon which the certificate issuing authority has no say but to do so. Section 8A of the 94 Act describes the constitution of State Scrutiny Committee and its power. Then, Lord 32, there is nothing in section 9, subsection 1 or 2 to indicate that reference to the State Scrutiny Committee is mandatory for an inquiry under section 9(1). Hence, the proposition iterated by me in Krishnapada, to the contrary, being against the law, is held to per incurium. Then 33, the decision rendered by the division bench in Bholanath Mahato did not lay down a blanket proposition that is mandatory for the certificate issuing authority in all cases to refer the matter to the State Scrutiny Committee for a report. The fact of the case are not clear from the judgment itself, and it doesn't necessarily be similar to the present case. Moreover, the question of such reference did not fall for consideration before the division bench. Hence, the observation made therein as to the report of the SDO being vitiated in absence of any report from the State Scrutiny Committee did not initiate a binding precedent for the proposition to the reference. Then, Lord, kindly come to page 36, para 36. Hence, in any event, there was sufficient justification in the cancellation of the petitioner's caste certificate on the premises that she did not belong to scheduled caste communities, but to the OBC. The order dated so and so passed by SDO in the manner exhibited that the SDO followed the due process and elaborately considered the question of petitioner's caste, not only on the basis of the report given by the BDO, so and so, but also on the basis of the detailed oral and documentary evidence. Thus, the finding arrived by the BDO could not be faulted with any perspective. The ratio of Rampal Sharma does not apply to the present case, since in the said report, no opportunity of the hearing was given to the petitioner. In such view of the matter, the impugned order cancelling the scheduled caste certificate was well within the authority of the sub-divisional officer and passed in consonance with the law and procedure. There is no scope to interfere with the order.
Yes.
Now, Lord, this is the order, Lord. His Lordship will consider. Now, Lord, if you Lordship kindly see the documents we have given, Lord, kindly come to page 52. Raw document, Lord, page 52. 50, Lord, 52. 52. Now, kindly see, Lord, subject notice for hearing under Rule 3 of the West Bengal Schedule so and so against the caste certificate. This is the Lord first notice of hearing on 18th September 24.
Yes.
Now, kindly turn the page. So-called notice. I have to place it in reference to the communication received from the Deputy Commissioner for Reservation and ex officio Deputy Secretary to the Government of West Bengal, wide memorandum so and so, concerning the grievance submitted by the Sonarpur Dhaba so and so Well Society regarding the alleged selection of non-tribal candidate for the post of assistant professor in the government aided general degree college under schedule so and so reserved category as advertised by the West Bengal College Service Commission. Preliminary inquiry report has been received from the block development officer, wide memo number so and so. You are provided an opportunity to submit original documents in support of your claim to ST status. However, if you fail to produce, then so and so. Then kindly come to page 56.
Yes.
This is the reply, Lord, given by the petitioner to the so-called notice.
Yes.
I will not place it, Lord, but they have given the copies of the documents. Then kindly come to Lord, page 66. Notice of hearing under Rule 3 of the so and so Act. Now it is not again Rule 3 hearing under Rule 3. Date is fixed. Then kindly come to page 68. 25th June notice of hearing under Rule 3 of the so and so Act. Reference to subject matter, you are requested to attend second hearing on so and so date. Then kindly come to page 68, 69. This is not 25th June.
Same notice.
Same notice. Sorry. 60. Then kindly come to page 70, my lord.
70.
70.
Yes.
It's again same notice.
Yes.
Then kindly stay to come to the impugned order. Page 76. Kindly come to page 76, my lord. It's very important. Lord, kindly see the top. Nature, the order sheet, the entire order sheet from 4th March 24 to July 26. 2 years this proceeding continued. 2 years. Nature of proceeding under section 9 within bracket 1 of the West Bengal so and so Act, read with Rule 3 of the rule for the cancellation, impounding or revocation of the scheduled tribe so and so of Mr. Mehdi Hussain, the petitioner. Now kindly see the first order. 4th March 40, received the formal directive from the Deputy Commissioner of Reservation so and so. The complaint has been received. The complaint has been received from Sri so and so, Secretary of the Sonarpur so and so. The complaint alleged the suspicion and fraudulent acquisition of scheduled tribe status.
Okay, these are order sheet, no problem.
No, then I placed 4 orders. This 4th March, then kindly come to 18 July. The preliminary inquiry report from the BDO has been received by him. The report recaptures the following critical baseline. Kindly see, Lord, in the same page bottom, 18 July. The first, the ancestral origin of the ST certificate holders' paternal lineage is recorded as so and so village with a long-term residency of roughly 70 years. The household language in Bengali and so paternal occupation in cattle rearing. Mr. Anil Haq is a school teacher. Thirdly, crucially, birth certificate and wedding custom, entire things, oral evidence, documentary evidence, it is recorded here. The enlisting officers field interactions at Tulsipur village, indicates that the family explicitly follow the culture norms of Muslim community and does not belong to the tribal Bedia community. Neighbors noted the family resided at Telindanga primarily due to the father's school teaching. A prima facie case of the incorrect or unentitled certificate classification having been established, the former inquiry sequence was ordered at this level. Now, look, kindly see the second 25th 9 24 order. 25th September. The case was taken for initial hearing. Certificate holder so and so along with sister so and so present. The hearing was conducted on behalf of the undersigned by Sri Vishwanath Saha, Deputy Magistrate so and so. The following points emerged during the hearing. To support his Bedia scheduled tribe claim, the candidate produced its ST certificate of his sister so and so, dated so and so. Discrepancies in paternal spelling were noted. No alternative historical documents such as ancestral land, deed, identifying tribal community, membership, father's caste was available. To extract socio-cultural indication, a written lifestyle questionnaires covering ancestry, traditions, habits, religion, rituals were submitted by the Mehdi Hussain. In the written questionnaires, the candidates declared his family to be the Ahle Heldu Islamic sector practicing standard Islamic prayers. The deputy magistrate and deputy magistrate and deputy magistrate Jangipur noticed that a definite tribal identification cannot be conclusively inferred from this answer. In these circumstances, it was recommended referring this structural matter to specialized state ethnographer. Then we'll kindly come to the next page.
No, please come to 25.
Mile.
The last which you are at the deputy magistrate and the deputy collector Jangipur notes the definite tribal identity cannot be conclusively informed from the answer in the circumstances.
In the circumstances, it was recommended referring the structural matter to specialized state to decide lot these points. Then lot kindly come to the order of 1st September. 1st September, order 1st September. A so-called letter dated so and so was issued to Mehdi Hussain. The candidate was directed to so-called in writing within 15 days. The receipt as to why his schedule. My lord.
That is a so-called notice.
Then lord, below that, my lord, the certificate holder, Mr. Mehdi, appeared and submitted a detailed written representation dated so and so in response to the so-called notice. The candidate reasserted that his Islam faith is anthropologically and demographically compatible with the Bedia schedule and tribe category, citing so and so. And specialized literature, he appended a screed of itself. Then, Lord, in the below 9th October order, case was taken for hearing. The candidate Muhammad Mehdi Hussain is present along with his block level representatives. Then, Lord, kindly come to page 79. The order of the 15th May 26. A conclusive deep dive inquiry report from the block development officer Farka has been received by memo number so and so dated 15th May 26. The exhaustive investigation was laid on site by the joint BDO. The report reveals following findings. The candidate was absent during the field inspection, but his father so and so was questioned at their home at so and so. No documentation supporting Bedia cultural traditions could be produced. The inquiry officer also questioned so and so petitioner close paternal blood relationship listed on his own notary family tree. Mr. So and so cousins were present. Critical finding: every single paternal family member explicitly confirmed that their ancestral lineage belongs to the Sirsa Bedia community, which is legally recognized as OBC under West Bengal. Under the West Bengal, the officers physically obtained copies of their active OBC certificates, so and so, issued by the very same authority. Now, Lord, in the 11 June order,
finding every single parental family members explicitly confirm that their ancestral lineage belongs to the
OBC
Sirsabedia community, which is legally recognized the other backward class.
OBC. They are OBC. Sirsabedia is OBC, but he gave the document. He is Bedia community. Bedia is scheduled caste. Now, Lord, 11 June order, can you see? Another hearing notice that is so and so was given.
So what has happened to this? This report was given to the petitioner.
Yes, this order was given to the petitioner.
Report 15.5. This report here relied upon.
Yes.
Correct. This report was given to the petitioner at the time of hearing. Supplied to the petitioner.
Yes.
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 Okay.
Now, Lord, kindly turn the page, my Lord. Page 80. Contradictions in family caste record. The critical discrepancies was observed when examining the family tree chart submitted by the certificate holder. Despite the claim regarding his father's lineage, other family members listed in the chart are documented holders of the other backward classes OBC certificate with subcaste Sirsa Bedia. Conversely, the certificate holder claimed that these family members belong to the Bedia subcaste. Reliance on the existing certificate. It was revealed that a scheduled tribe certificate was issued primarily on the strength of existing EST certificate held by his sister so and so. Like them lot, lack of documentary support when directed by the chair to produce concrete evidence validating his tribal status. Mr. Mehdi Hussain presented generalized statistical and historical census data pertaining to Bedia's tribe. However, he failed to produce any relevant documentary evidence to substantiate his claim. When questions about the geographical roots, ancestral migration, and cultural origins of the community, the certificate holders displayed complete ignorance and could not produce any answer. It was further established that the holders' claim of belonging to Bedia community is based entirely on the local hearsay and verbal assertion by neighbors rather than the family members. Now, look, kindly say final order. The page 81, my lord. 25th June 26th order. Then, Lord, 2nd July, currency proceeding and the evidence. The paternal cousins submitted a written declaration and joint family tree chart. In this declaration, they explicitly testified that a grandfather of the entire lineage is Lokman Ali, and that the entire family across generation belong to Sirsa Bedia community. They submitted their copy of the OBC certificate for verification, which were verified from the official portal, that is Oscar portal. They further noted that Muhammad so-and-so's family has lived separately from them, and they are completely unaware of the how or on what ground their immediate sibling obtained SC certificate, as the true paternal lineage has no tribal issue. Mr. So-and-so was confronted with his definite evidence and the certificates of his own cousins. He was entirely unable to resolve the fatal contradiction of why his paternal cousin possessed genuine, legally and verified OBC Sirsa Bedia record, while he claims a scheduled tribe status. He could produce no historical land or ancestral record or counter joint testimony of his own bloodline. Now, look, kindly see page 82, final order. Upon a careful consideration of the entire materials on record, the documentary evidence, genealogical records, report of the entire officer, and the submissions made under the proceeding, this authority is fully satisfied that true paternal lineage of the family is rooted exclusively in the Sirsa Bedia community, which is recognized as as other backward class OBC under the state West Bengal, and the family has no paternal, ancestral, or genealogical relationship whatever with the Bedia scheduled tribe. It is conclusively established that a scheduled tribe status claimed by the family is not genuine and has been obtained by suppressing the true paternal community identity and misrepresenting the material facts. The inquiry further established that Mehdi Hussain, son of so-and-so, fraudulently obtained scheduled tribe certificate number so-and-so, dated so-and-so, misrepresenting his true paternal community and suppressing his baseless identity reflected in his family lineage. He produced the scheduled tribe certificate by producing his elder sister, Umena Kusum, as a paternal linkage. However, Umena Kusum herself has also failed to establish her claim to be a Bedia scheduled tribe on the same ground. Consequently, the inquiry confirms that Mehdi Hussain and his 7 siblings, namely so-and-so, likewise procured their respective scheduled tribe certificates on a very same false representation of the paternal lineage and by suppressing the true community identity and the family. Since all 8 siblings derive their caste claim from the same paternal lineage, and the very foundation of each of the scheduled tribe certificate is identical and has been found to be false and legally so-and-so. Therefore, under section 9(1) of the Act and Rule 345 of the Act, this authority hereby order that the scheduled tribe certificate of so-and-so having all been obtained through fraudulent identification of their paternal lineage and suppression of the facts are hereby cancelled, impounded, and revoked. Let the copy of this order be communicated to so and so and so.
Yes.
Now, there is no violation of any any provision of law.
Yes.
This has been carried out under sections 9 within bracket 1 of the Act, which does not require any recommendation of the scrutiny committee. Therefore, kindly don't interfere with the order and kindly dismiss the petition. That's all, my lord.
For the industrial district, what was the necessity of not incorporating the non-obstant clause in 9? Right. That has to be first appreciated. Now, not drawing upon the rules of 1996 and the Act is amended in 2007, and that is for the resultant product of the Supreme Court treat. Now, kindly takes up 1994 6 Supreme Court case, which was relied upon by this court also in another matter. But the Supreme Court was very categorical that SDO being the issuing authority cannot undertake the cancellation process because it requires huge sociological evaluation. That's why the screening committee. Now, I just invite my lord's attention to the relevant paragraph 11 to paragraph 11 to give the factual background, not in detail but in short. It is seen that admittedly the appellants reside in Muland area. The first instance, so rightly approached Tahsildar having jurisdiction of the area who refused to give a social status certificate as so. She filed an appeal and High Court directed the Deputy Commissioner to dispose of the appeal, who in turn, without deciding the facts, directed the Tahsildar to issue the certificate. In the meanwhile, he had by orders of the court got admission, so I'm not troubling my lord. Then kindly come to the paragraph 2. Paragraph 30.
Yes.
The admission wrongly gained or appointment by just keep over, kindly come to Supreme Court direction. For that purpose, it is
Necessary
to streamline the procedure for the issuance of social status certificate, their scrutiny, their approval, which may be the following. The application for grant of social status shall be made by the revenue officer, deputy collector so, the parent and guardian of the candidate, as the case may be, shall file an affidavit. These are the procedure. Then all the state government shall constitute a committee of 3 officers, namely additional so. As the case may be, in the case of scheduled caste, another officer who has intimate knowledge in the verification and issuance of the social status certificates. In the case of scheduled tribe, research officer who has intimate knowledge in identifying the tribes. So these are the special category which was contemplated directly by the Supreme Court. Here, the SDO takes upon himself to be the specialist authority. Each directorate should constitute a vigilance cell consisting of senior deputy superintendent of police in overall charge and such number of inspectors to investigate the social status claims. The inspector would go to the local place of residence and original place from which the candidate hails and usually resides, or in case of migration to the town or city, the place from which he originally hailed from. The vigilance officer should personally verify and collect all the facts of the social status claimed by the candidate or the parent or the guardian, as the case may be. You should also examine the school records, birth registration, if any. You should also examine the parent, the guardian, or the candidate in relation to their caste, etc., or such other persons who have knowledge of the social status of the candidate, and then submit a report to the directorate, together with all particulars as envisaged in the pro forma, in particular the scheduled tribe, relating to their peculiar anthropological and ethnological traits, deity, rituals, customs, the mode of marriage, death ceremonies, method of burial of dead bodies, etc., by the caste or tribes or tribal communities concerned, etc. The director concerned, on receipt of the report from the vigilance officer, if he found the claim of social status to be not held with, or doubtful, or spurious, or falsely or wrongly claimed, the director concerned should issue show cause notice applying a copy of the report of the vigilance officer to the candidate by registered post, with acknowledgement due or through the head of the educational institution concerned in which he can be studying or employed. The notice should indicate that representations or reply, if any, would be made within 2 weeks from date of the receipt of the notice, and no case or request not more than 30 days from the date of receipt of the notice. In case the candidate seeks an opportunity of hearing and claims an inquiry to be made in that behalf, the director, on receipt of such representation, shall convene the committee and so and so. But these are the details. I don't waste my last time. Now, then the act was purportedly will not amended and notwithstanding clause of the section 9(2) was broken. But had below the SDO the complete authority question of the 9(2) wouldn't have as at all. The Mabhi department wouldn't have at all been considered. This is the factual aspect on which I for the first day only say that this is the lacks jurisdiction. The matter ought to have been done by the speaking committee. Now, interestingly, since he has placed in detail all the orders, I will just take your lordship to a portion of the order which will disclose how he had applied his mind. First of all, what he is recalling a certificate which was issued in the 20 years back. The certificate was obtained in 2007, 2005, and then in 2024 he
Report.
what is a suo motu inquiry was hereby initiated under Rule 3A. So that a suo motu inquiry must have some foundational basis. It cannot be ipsi dixit. A letter was sent to the BDO for local field inquiry. The field inquiry report from the BDO has not yet been received. And then reminder was given. Then said the preliminary inquiry report from the BDO has been received with a memo dated 18th July 2024. This report was never supplied to me, but he records while passing order. The report captures the following critical baseline observations. No, I am not troubling my lord. Then kindly come to an important part of it. The order dated 30th of October 2024. Page 77 at the bottom. A letter addressed to the Director, Cultural Research Institute, Kapurgachi. The institute was provided with copies of the preliminary block inquiry report, the lifestyle questionnaire, and the initial hearing briefs. They are requested to conduct an expert identification mapping of the candidate's lineage and share their expert anthropological findings. Peruse the record, no communication or analytical report has been received from the Calcutta Research Institute. Now, these are the foundation of without arriving at the decision to cancel it. Then, in view of the urgency of the matter, a reminder was sent to the Director CRI requesting early transmission findings. Considering the extensive time elapsed, the foundational cultural admissions made by the holder during the block level inquiry is a formal executive step is initiated. Without having the ethnocultural report, which is foundation, he proceeds. Then, Lord, I am not troubling my lord, with other things, Lord. Kindly comes to me, Lord, the further report was obtained by the BDO. Second report, page 79. Here the report records on the order dated 15 May.
Yes.
On 29th of the report was received from the Pradhan, but the report is not conclusive. Then a conclusive deep dive inquiry report from the BDO has been received with a so. The exhaustive investigation was laid on site by the joint BDO. The report reveals that a candidate was absent during the field inspection, but the father was there. No documentation supporting Bedia cultural tradition could be produced. But the law says that oral evidence would be sufficient. That is without the law itself says. Then without he proceeds. Then the report also notes that while candidate holds the ST certificate issued in 2007, his actual family practices, ancestral blood ties, and cross lineage records are completely detached from the Bedia tribal identity. Now, if the cancellation is proceed on this sort of ipsi dixit, and the persons are well settled in the society, it becomes difficult. Then kindly will not the empowerment is kindly again not sees the language of the statute. That a false representation, they do not come to any conclusion. They come that say this is according to their identification is not matching.
Yes.
The Act says by furnishing any false information. or by misrepresenting any fact, or by suppressing any material information. How do you exercise your power? It must be exercised within the four corners of these areas. That's why the question of the screening committee, because screening committee comprises as per section 8A by the expert persons. Kindly just turn to the section 8A, who are the persons nominated by the government in the screening committee. Secretary of the backward classes, welfare department, commissioner, directorate backward classes, director of cultural.
Where from you're reading?
8A, section 8A.
Yes.
And this director, Cultural Research Institute, who did not, my lord, submit any report. There is a community that they are not disputed.
Yes.
They are trying to say that you belong to area which is the Shersha area, but therefore you are OBC.
Correct.
How do you come to this conclusion without having the
That's
cultural
it.
report?
They have come to the conclusion you are the Sirsa Bedia. So you are the Sirsa Bedia is coming under the OBC.
OBC, therefore,
The
you are
OBC, so that's why you have obtained the tribal certificate only on the basis of the Ume Kulsum, the sister or whatever it may be.
But that requires the socio-cultural report. That is foundation. And the question of the oral evidence also necessary. All these things were disclosed. You ought to have considered what are the materials which was before the authority while issuing the certificate. And come to the conclusion those certificates are all false or forged.
Yes.
Because this is on merit in detail. I wanted to be not assured that the certificates were issued genuine. It should be cancelled only after proper scrutiny by a screening committee. That's my prayer. I do not say that you declare me as Bedia. I say the screening committee, after appropriate and proper verification, will ultimately come to conclusion that it belongs to Bedia. But there are many sub-classifications, Lord is well aware. And that's why from time to time the president has to issue an order incorporating the particular community, whether ST or SC. That Bedia was, as per the presidential order of 1950, West Bengal Bedia is one of the ST community. Part Roman 16. Oshud, Vaiga, Bedia, Bhumij, Bhutia, Sherpa,
Bedia and Bedia. Bedia and Bedia.
Yes.
And Sirsa Bedia, where is the where from you got the Sirsa Bedia in that?
That is because subsequently after Mandal Commission, the Sirsa Bedia was done in the OBC. Well, you have to see when this certificate was issued.
No, what is this? The same.
This is the amendment order of 1976.
No, this was 1950. 1976.
Here also Bedia is also in the ASC. But it requires a detailed study. I would, with respect to the SDA concern, basic question would be, how could you take suo motu cognizance? What is the fundamental material?
Yes.
And how could you proceed without the cultural report? You say, I do not get the report, then forget about it.
Yes.
So these are the considerations, Lord, in which I will most humbly appeal that the entire thing should be set at naught. It should be referred to the screening committee and let the screening committee decide.
Lord, only 2 points. One, Lord, the evidence, writ court will not reappreciate the evidence, Lord, adduced by parties in the writ court. Lord, it does not.
No, but you come to page 79, my lord. You have called for the report. Page 77, order dated 30th October 2024.
77, order dated, my lord,
last 30 October 2024.
30th October,
Huh?
30th October.
30th October.
Huh.
Correct. A letter addressed to you are sent to the director culture. So you wanted a report from the expert of the anthropological. Correct. Pursue that no comments has been received. Thereafter, in view of the urgency, without that report, you have proceeded with the so-called notice. So what was the urgency?
My lord, the so-called notice was issued and that point was taken by the,
Question is that once you have taken in mind as anthropological director's report is required, and you have, but you have not, you without waiting the report, or you have started the proceeding and call for the report from the tehsil, and now kindly come to this, kindly come to the page 79, order dated 29th October. A report was received for the Pradhan Bewa Gram Panchayat, but the report is inconclusive. So how you came to know?
but there are, my lord, the evidences of all these family
Which
members,
evidence?
the family members,
Ah.
the petitioners, the documentary evidence, the oral evidence.
So Sresha Vidya come, when the Sresha Vidya was notified as the scheduled caste,
So that has,
OBC,
that is, my lord, huh? OBC, yeah.
when it was brought on OBC on Sresha Vidya
OBC law. After 94.
after 94, when the the certificate was issued to the petitioner.
That is not prior thereto.
Sir?
No,
That-
that's why I'm telling you, Lord, if these points are to be considered by the appellate authority, not by the writ court. Let him go and
Once
file an
you
appeal.
have not proper follow the procedure,
Lord, proceed.
you have not follow the procedure, you have asked for the report from the
There may be some discrepancy in the order sheets,
Hmm.
but not that does not make the order vitiated or invalid.
Okay. Okay, I will take
I'm not one more point, my lord.
Yes.
Kindly take section 8A and 8B.
Hmm.
Not the section which was amended
Hmm.
and the committee was formed.
Hmm.
8A and 8B, kindly see.
Yes.
8A, the state government may by order constitute a committee.
Yes.
Of these members. This is 8A, committee of these members.
Yes, 8A.
8A, my lord.
Hmm.
The state government may by order constitute a committee to be called the state scrutiny committee.
Correct.
To be called the state scrutiny committee for verification of the social status of the persons. And these are the members. 8A. Now kindly say 8B. The state government may by order constitute a vigilant cell for each district of West Bengal.
Hmm.
These are members. These two sections, my lord.
Yes.
Now we'll kindly come to 9 subsection 2.
Correct.
Notwithstanding anything contained in subsection 1, if the committee,
Hmm.
this 8A and B is straightway followed by the following in 9.2, not in 9.1. It's for 9.2. This
9.2. You have an old act. You have an old act. See the old act 9. See the old act 9.
Yes.
What is the old act 9? Because it was only 9. Subsequent 2009 1, 9 was the 9.1, then incorporated 9.2.
Yes.
By a notification of 2007.
Yes.
Why 9.2 added?
That too is the one of.
And 8A also on 2007.
Yes.
So these are also in consonance with all
Yes,
sections.
consonance in this. Yes.
Then
You know, I'm not telling you that 9.1
because
proceeding is
the
in any-
judgment of the coordinate bench that has not been brought to the notice of this court. The judgment of Justice Bhattacharya, this was not brought to the notice of this court. That's why the court has held that that was a per incuriam. But this was not brought to the to the honorable judge. Why? If okay, I accept your submission 8A. 8A. So why the committee? For which?
No, 8A, 8B is a committee.
Why the committee?
Right, in 9.2.
Why this 8A is the committee?
Right, 8, that is not an independent organization, Lord, for justification of the.
Why?
There are two mechanisms, I said you. Two mechanisms. One suo motu by the.
It is not that the issuance of the certificate, the committee. Issuance of certificate is the authority. Cancellation, the committee.
No, my lord. cancellation by the issuing authority. Kindly see 9.2.
Okay, I will pass on.
Not the cancellation will be done only by the issuing authority.
Issuing authority, first issuing authority will inquire.
Yes.
And he found that yes, it has to be dealt with, then it has to be go to the committee. Then committee will again inquire into the matter,
That's not right.
taking into all experts report, all the anthropological report, all the guidelines. Then if the committee finds that yes, the certificate is not entitled to have the certificate and wrongly issued the as tribal certificate, then they will recommend and send to the issuing authority for cancellation.
No, that not contrary to this order of the Justice Bhattacharya. He has not considered
That's
that.
why Justice Bhattacharya, that's I'm telling, Justice Bhattacharya order, it has not been placed or the court has not gone into the amendment portion. Why the amendment has carried out on 2007? An amendment 2007 only, not a simply 9.1, 8A.
80 and 8B
No,
both.
but that too, not one single judge cannot declare the other judgment as an inquiry, per inquiry, and ought to have been referred to the larger bench. Anyway, that's a different thing.
That is, we are not going.
No, last time
Okay, let me
my lord, kindly, my lord,
apply my mind.
my lord.
Hearing
I'm not
concluded.
appeal point, my lord, consider
I will take.
amended in 22.
I will take.
All these points they have to go, they can prefer an appeal also.
Sure.
Instead of coming to writ court,
Yes.
they can go in appeal court also.
Hearing concluded.
I am grateful to Lord.
Next.
This matter, my lord, last occasion when this matter has been taken up, the lordship had granted liberty to the respondents to come up with a supplementary to their affidavit in opposition because they wanted to place certain new documents. That lordship had granted us liberty to come up with a reply. And as we are here with the reply, we could just serve it on them just now.
Respondent is given liberty to file supplementary
file the
affidavit
supplementary
on
affidavit.
17th
Yes, ma'am.
filed,
Yes, my lord, kindly. Our reply.
and the petition liberty to file exception. You are filing exception. Yes.
That we could serve it on them just now. Just today, my lord. Maybe. Please we have received the copy.
What is the matter?
Well, Mr. Dotto has already placed it extensively for your lordship. This issue basically a contractual, tender related issue, whereby the petitioners have requested the foreclosure of the agreement. They have a stance that
Acha.
thing is with
Okay.
regard to
Yes,
a civil dispute.
Supplementary affidavit filed by the respondent number 125 and the affidavit in opposition to the supplementary affidavit filed by the petitioner be kept in the record. It is found that the pleadings have been completed, the matter is ready for hearing. In view of the above, let the matter appear on September 12 noon. 23rd September 12 noon.
Great for you.
Next. Yes. So the petitioner is a chronic schizophrenia. No, petitioner brother. Petitioner brother.
Yes.
Correct. Come to, they will not give any answer. Come to, you have to decide that. Yes, where is the schizophrenia? Chronic schizophrenia. Who?
Is the
dictionary is appointed under the National Trust Act. It's with right of the persons with disabilities Act. Then entire mechanism, and also enunciated in the Act, the section 16.
16 of
National Trust Act.
National Trust Act.
Yes. Already
You are having.
the copy number. Given my-
State party আছে দাদা? But I am told Mr. Devashish Basu is
Yes,
appearing for the
Devashish
state,
Basu is appearing
but he is
as a-
on legs in court number 1, my lord. I'm just
Let me remain in the court number 1. Where is the act? Let me see the act. पता है रे लोग कहाँ डाल देते देने से क्या करते बुक ना section 70 14 section 16 under which act you are referring? National Trust for Welfare and Persons of Autism. Yes, that is section 14.
Section 16. The guardian who parted the inventory.
First we come to the page 14, appointment of guardian. A parent of the person.
Or you make an application to the local level committee for appointment of any person of his choice to act as a guardian of the person with disability.
Yes.
Already I have made that application for decided. Any registered organization may make an application.
A parent or a person with disability or his relative may make an application for local government or person to choice of guardian. Yes. Then.
Yes. Section 15 deals with my duties after being appointed as guardian. And 16, what minor actually fallen from the guardian. Also.
Yes.
What expenditure I will submit? What is the audit?
Every person appointed as a guardian under section 14 shall within a period of 6 months from the date of his appointment delivered to the authority.
An inventory of immovable belonging to the person and all assets, other movable property. Wherein my family pension is connected to my received on behalf of the person with the statement of all claims and all dates and liabilities due to such person with disability.
Yes.
The actual query, what my love, your last.
Correct.
Correct. Yeah, I have the commissioner.
No, that is correct. But with regard to the under this section, under this act, the person who is suffering suffering from chronic schizophrenia can be appointed as a guardian. Yes. Where is that? Yes. Yes. Yes.
Of 1999 Act of National Trust Act. The person with disability as follows. Person with disability is the person suffering from any of the conditions related to autism or a combination of or most such conditions and include the person suffering from several multiple disabilities. There is two limbs. One will not
Includes a person suffering from severe multiple disability. Correct.
Okay.
Hmm.
One, the autism, cerebral palsy, mental retardation, and another name gives to the such condition includes a person from severe multiple disability. Mother kindly comes to age of the same. What do it says? Multiple disability means a combination of two or more disabilities as defined in the clause 2 of the 2I Persons with Disabilities of Equal Opportunity Protection Right and Participation Act 1995. I'm showing you. The disability means
Multiple,
blindness, low vision, leprosy,
multiple disabilities where it is? 2I.
mental illness.
What is this act?
This act, wait, the
What is this act?
The act is persons with disabilities, opportunities of protection of rights and participation.
Yes,
Which has been referred by section 3 in the national law.
correct.
Kindly see the in particular section I have already marked where
2I. 2I.
2I
Disability.
disability, particularly mental illness is there.
Yes.
Yes. Now that act has been written.
No, disability means blindness, low vision, leprosy cured, hearing impairment, local disability, mental this is the only thing.
Yes.
Schizophrenia is not there.
Schizophrenia, directly schizophrenia.
Correct.
is not there.
Correct.
I am
Mentally illness.
mental illness coming under that one.
Mental illness or mental retardation.
Yes. Particularly below 2016 has been filled by RPWP Act, Right of Persons with Disability.
Correct.
And this particular act, clause 3 of the schedule, again says that mental illness means substantial disorder, perception, orientation, memory that grossly impairs judgment.
Where from you are reading?
I am giving the book. I'm just giving the book. The RTR 1995 Act is filled by the this act.
This has come into 2016. What is that? The Rights of Persons with Disabilities Act 2016.
Yes.
Mental illness means a person disordered of thinking, mood, perception, orientation of memory.
That grossly impairs judgment, and capacity, sometimes ability to meet the ordinary demands of life.
Yes.
But does not include retardation, which condition arresting incomplete development of mind of a person specifically characterized by subnormality of intellect.
Yes.
That question comes to mind.
Yes.
And my lord, kindly comes to 2R of
Which act?
this article.
No, but this mental behavior, where from you? This is a schedule of disability, schedule 3.
Schedule 3.
Yes,
Schedule 3 of this act.
schedule 3. Not section 3.
No. Clause 3 of the schedule. Clause 3 of the schedule.
Schedule. Oh, this is-
Clause 3 of the
yes.
Now, my lord, kindly comes to R.
Yes.
Very fine.
Yes.
Person with benchmark disability.
Yes.
A person with not less than 40% of specified disability where specified disability has not been defined with a measurable term and includes a person with a disability where specified disability has not been defined with a measurable term as certified in the certifying office.
Yes.
In my case, the certifying office already certified me as 55% disabled person.
Person with not less than 40% of the specified disability where A specified disability has not been defined in the measurable terms and includes a person with a disability when the specific defined in the measurable. Yes.
So, my lord, this is the main reason harmonized rating with the national trust act reads with the RPW. So once I have been appointed under the national trust act section 40, as Jibabu Judgment confirmed by, Jibabu Judgment says that yes, I can be appointed under section 40 as the national under the national trust act. The mechanism from controlling authority already automatically comes from section 47.
Yes.
So, my lord, at last, I am relying the judgment already. My lord, having so judgment just in the paragraph 21. That's the copy.
Judgment of?
So, already I have identified. I am
Yes.
that part. Paragraph 21. The principle of purpose interpretation adopting an approach the expression person suffering from multiple disabilities.
Paragraph
21.
of G Babu.
So,
Yes.
paragraph 21.
Ah.
Eight, nine, adopting such an approach, the expression the person suffering from the multiple disabilities occurring in 2J of the 1999 Act must be understood to mean a person with benchmark disability as defined in the 2R of the 2016 RPW. And adopting such approach enables the local level committee to deal with the cases of appointment of guardian for persons suffering from any kind of disability. So, local level committee headed by the DA cannot show their liability to control me, or they cannot say that we don't have any authority.
Okay.
Deals with the appointment. The local level committee constituted Central Act of 1999 should not confine themselves to the cases congenital conditions such as autism, cerebral palsy, mental retardation alone. That is the first question comes to our mind. How they will deal. They should also deal with the other disabilities. If I harmonize with RPW, then the national transplant has the authority to appoint, to control me, all the other things. Entire mechanism is there. The 1999 Act should be applied in the light of the new RPW Act and not in the light of the 1995 Act. It may have so because easier to secure appointment of guardian under 1999 Act. Approaching the High Court and getting orders expeditiously may not always be possible. So, if the local level committee under 1999 Act has the power to appoint guardian, that certainly enables easier, quicker access to them.
Yes. That's all. Yes, where is the state?
Lordship, I am for the state, led by Mr. Devashish Basu. He is engaging from another court.
Let it be engaged, continue. Yes, hearing concluded, CAV. Hearing concluded, CAV. Okay, now, ekta kaj karo. The petitioner has filed the presented application praying for an order for appointing the petitioner as legal guardian of her disabled brother namely Gautam Kumar Bose, who is suffering from chronic schizophrenia with 65% benchmark disability. Now, counsel for the petitioner submits that the petitioner and the brother of the petitioner is diagnosed and is suffering from chronic schizophrenia. Chronic schizophrenia. The medical board has examined the brother of the petitioner and found that where is the certificate that he is suffering from schizophrenia. Now, where is the percentage? It is not declared. Where is that? अच्छा क्या बोला? Examined the brother of the petitioner and found that he's suffering from 65% temporary disability in relation to his brain, as per the guidelines. As per the guidelines within bracket guidelines for the purpose of assessing the extent of specified disability in person included under the RPWD Act 2016, notified by the Government of India by SO 1338 within bracket capital E, dated 12th of March 2024. The said certificate was issued on 8th of January 2025 for 9 years 11 months. 9 years 11 months and is valid till 22nd December 2034. As the brother of the petitioner is suffering from chronic schizophrenia, having 65 is suffering from chronic schizophrenia and is not able to take his decision, the petitioner has made an application to the concerned author, to whom you have made the application? To the district magistrate as well as the social welfare officer for appointment of the petitioner as guardian of her brother. On receipt of the on receipt of the application submitted by the petitioner, the district social welfare officer so you apply for the legal guardian certificate. You applied for the legal guardian certificate. Where is the legal guardian certificate? On receipt of the. Now, what has happened to your this representation? What has happened to your representation?
You have to approve the portal.
Where is that? Where is that?
Page 40.
What is they are telling that a legal guardian said that is a reply to your representation? I don't think so.
Yes, yes. In reference to a later dated issuance of legal guardian certificate, guidelines of issuing legal guardian certificate, all applicants must apply to legal guardian website to National Trust Act. Also inform that there is currently no application pending on the following
application. District social welfare officer Nadia informed the petitioner to obtain legal guardianship certificate for taking further action. On receipt of the said application, on receipt of the said reply from the district social welfare officer Nadia, the petitioner has again made a representation to 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 the district magistrate as well as the social welfare officer, intimating that 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 the petitioner has accessed the online portal of the National Trust to register her application for appointment as legal guardian of her disabled brother, but but the portal is not accepting the application of the petitioner. Application of the petition. Full stop. Accepting the petition, and as such the petition unable to process due to invalid UID number or invalid date of birth of the why it has been shown as a invalid? Page 42. Page 42.
They are showing a unable to proceed due to invalid UPID, invalid date of birth, invalid disability type, or
Invalid date of birth,
percentage
an
is
invalid
less than 40.
disability type or disability percentage is less than 40. But the petitioner has submitted the correct date of birth and the disability certificate, which shows that the board of doctors have provided the certificate of disability of 65%. Thus, the petitioner has filed the present application. Present application. Hold on. The petitioner submit that. Petitioner submit that. The as per as per section 14 of the National Trust for Welfare of Persons with Autism, cerebral, cerebral palsy, mental retardation, and multiple disabilities Act 1999. The procedure for appointment of guardianship, duties of guardian and the duties of the guardian and guardian to furnish inventory and annual accounts is prescribed under section 14, 15, and 16 of the said Act. The petitioner has referred section 16 of the Act of 1999 and submits that as per the said Act, the petitioner is ready and willing to deliver the authority who will appointed the petitioner an inventory of immovable property belongs to his brother who is suffering from cerebral who is suffering from 65% of schizophrenia, and he will comply all the direction and he will submit the accounts before the concerned authority. The petitioner has referred section 3 of Right to Persons with Disabilities Act 2016, wherein has referred schedule rule clause 3 of schedule 3 of the rights of persons with disabilities Act 2016, wherein the mental behavior has been defined. As per the said provision, the mental illness means a substantial disorder of thinking, mood, perception, orientation or memory that grossly impairs judgment, behavior, capacity to recognize reality or ability to meet the ordinary demands of life, but does not include retardation which is a condition of arrested of incomplete development of mind of a person, comma, specifically categorized, characterized by subnormality of intelligence. He further referred, section 2I of the PWD Act 1995, the persons with disabilities within bracket equal opportunities, comma, protection of rights and full participation Act, comma, 1995, wherein the disability has been mentioned. As per section 2I of the said Act, disability means blindness, comma, low vision, comma, leprosy cured, comma, hearing impairment, comma, locomotor disability, comma, mental retardation and mental illness. By referring this said provision, comma, the petitioner submit that the case of the petitioner is duly covered under section 2I within brackets 7. That is mental illness. That is mental. He submits that the as per section 2R of the Rights of Persons with Disability Act 2016, the persons with benchmark disability means a person with not less than 40% of a specified disability, where a specified disability has not been defined in measurable terms and includes a person with a disability where a specified disability has been defined in a measurable terms as certified by the certifying authority. Section 2S provides the persons with disability means a person with long-term physical, mental, comma, intellectual or sensory impairment which, comma, in interaction with barriers, comma, hinders his full and effective participation in society equal with others. By referring the above said provisions, comma, the petitioner submit that the case of the petitioner is totally covered under the provision, under the definition of mental behavior. And section 2R with regard to the person with benchmark disability. Full stop. The petitioner has referred mental health, you have referred the one section, no? It is not referred. Full stop. Mr. Counsel for the petitioner has relied upon the judgment in the case of G. Babu versus District Collector and others, reported in 2023 SCC Online Madras 568, and submit that in the said case the Madras High Court has held that invert comma यहाँ से लेकर ठीक है. By referring this judgment, comma, the petitioner submits that in the case the case of the petitioner is duly covered with the said judgment. He submits that the petitioner is suffering from chronic schizophrenia with 60% disability. The board of doctors have provided the disability certificate for 9 years, 11 months, which is valid up to 22nd of December 2034. The authorities have, in spite of requests made to the authorities, the authorities have not appointed the petitioner as guardian, only directed the petitioner to apply for guardianship, legal guardianship through online. But the online portal is not accepting the request of the petitioner. He submit that the petitioner is suffering from the chronic schizophrenia, which the petitioner is suffering from is covered under section 2J of 1990 Act. 1990 Act and the schedule, clause 3 of the schedule, wherein it is mentioned that wherein the mental illness has been defined. Considering the submission made by the counsel for the petitioner, peruse the materials on record and the judgment relied by the petitioner. This court find that the petitioner is, this brother of the petitioner is suffering from chronic schizophrenia, having 60% disability, 65% disability. That has been certified by the board of doctors, and the certificate is valid for 9 years, 11 months. That is up till the year 2034. The chronic schizophrenia has not been defined in any of the act with regard to the disability. But Schedule 3 and Clause 3 of Schedule of Right to Persons with Disability Act 2016 define the mental illness. Section 2R and 2S of the said act also define the persons of the benchmark disability and the person with disability. The Madras High Court in the judgment of G. Babu Supra has considered the said provisions and come to the and has held that appointing such an approach would be enable the guardian for the person suffering from any kind of disability. The local level committee constituted under Central 44 of the 1999 should not confine themselves to cases of congenital conditions such as autism, cerebral palsy, and mental retardation alone. They should also deal with other disability. The 1990 Act should be applied in the light of the new Act of RPWD and not in the light of the repealed Act 1995. Full stop. This court is also of the view that if the petitioner is suffering from chronic schizophrenia having 65% disability, the authority cannot deny it for appointment of the petitioner as guardian of her brother who is suffering from chronic schizophrenia having 65%. Accordingly, the writ petition is disposed of by directing the district magistrate, the respondent number 2, to consider the representation submitted by the petitioner dated 8th of September 2025 after giving an opportunity of hearing to the petitioner and to pass appropriate order for appointing the legal guardian of her brother who is suffering from chronic schizophrenia having 65% by considering the certificate issued by the board of directors within a period of 3 weeks from the date of receipt of this. Order.
Grateful.
Good. That's why you dispose of herein now. Let it be, you take back. Which one?
Yes, our junior is here.
Look, let it be there. I will correct and you take.
Lordship, where for the states, Lordship.
Record
junior
you. I will record your name. Record her.
Grateful.
Because it is a law point.
Yes, Lordship. Last occasion, Lordship also directed to us. No, Lordship, we are ready to, but we
problem.
don't find any answer.
Interpretation, you know the IS officers. That is a problem. But none, they will not. Again and again, you have to come to the court. It is the benefit of you person.
We are ready to comply, Lordship. Grateful.
Frame the guidelines. Frame the guidelines.
Yes.
Why the disabled person should come to the court?
Lordship, actually, schizophrenia is not covered.
That's why the frame, in terms of the guidelines, the
Lordship,
order,
Lordship.
to frame the guidelines. So, and to circulate to all district magistrates so that the all persons can get the benefit.
Lordship. Yes.
Well, known fixed pattern, I don't know, 177, 178.
Yes. Well known. Yes. Doctor choice.
A doctor's choice is not an automatic choice. It is something only that becomes a choice by protracted use over a number of years. That's why I told you that this doctor's choice will be first district. That's the logic of made it. Trademark registration, advertisement, sales turnover, all that I've got showing about. Defending the mark against other questions for marks, court orders, and I've shown you lordship all of that. But what I've also shown you lordship is very importantly, similar to expression of volume 1, page 64.
Which one? WPA?
This is my
29273. Yes, that is going on.
Just page 61, very
License.
license. Doctor finds that this was caveat around the 12th of January 2020 by the same authority. Well, they had no caveat of doubt in their mind. That this is not something case confusion or renewed right up to 30th May 2020 for a period of 5 days. But it is thereafter that the whole problem starts. This body called filing multitude of complaints. Ultimately, on the basis of these complaints that include very important. All these notices you will also find that issued under section 30. Well, at section 30 of the Act provides for improvement, but not for banning it. And all these notices ultimately require compliance with the
Yes, you submitted that all improvement have been made. They have satisfied with that, and they have issued the notice and without any disclaimer.
That's right. And under section 33, banning can only be after I think show you lots of the provision. But what is very important is that the entire complaint started from time to and ultimately these complaints underwent a change. I've shown you lordship the complaint. I've also shown you lordship that this was also escalated to the Consumer Protection Authority. The Consumer Protection Authority called for reports on the FSSAI. FSSAI gave their report and being satisfied that there was no further reason for any consumer complaint or consumer confusion. Ultimately, the Consumer Protection Authority also gave a plea. Well, I've shown you lots of those orders. I'm not going to go back to this. But one thing which is very important is the lots will see how the complexion of the complaint changes. Page 373, when the bill is March 2023. Now, I won't read the whole thing. But first, your lordship will see that this is an improvement from section 30. Then, when if your lordship see, paragraph 2. Alert, grounds for improvement are, if you observe from the front of the bag that the brand name Doctor's Choice, along with symbol and stethoscope in the shape of part of the label of prospering. And for that they allege that there is violation of section 4 and regulation 434. I should take your lordship through that later. I'll not trouble your lordship more with this. Then after this, so far as this is concerned, this was followed by a complaint at page 377, 2023.
This is also improvement.
Yes, this is also improvement under section 32.
Correct.
Well, I just want to show you lordship one small part of this. Please see the grounds again. The regulations are quoted. I don't want to talk about that. Grounds to paragraph 2. Erroneous brand name, Doctor's Choice, and pictorial representation. So this was the complaint for the first notice. And I was called upon to make an improvement. Now, my lord, I do that improvement. I've shown you lordship all those, my lord, documents.
Yes.
And then the third complaint, that is the page 375. And very interesting, your lordship will find, this is also under section 30.
Yes.
And now the grounds have changed. Please see whether true. Misleading claims on official website. So they have no problems with the labeling anymore.
Misleading official website. Claims on official website.
It has been observed that Burger Refineries is promoting its products on its official website as healthy, cholesterol-free, and unadulterated oil. Using of such terms also undermines products of the same category available for the entire character of the complaint. Now, they are no longer concerned with the representation of the label. Now, thereafter, so far as this is concerned, there was an action taken report that your lordship has seen under the page 308. I have shown that.
Yes.
380 lordship see at the last one.
380.
380.
Yes.
This is the reference to the actions of listing and then two following actions were taken. Here, one observation was made, which Mr. Mukherjee wanted to capitalize on. You'll also see, first of all, what is the following actions taken? Improvement notice 15 March served. Improvement notice served, wherein FBO Bajbaj has replied to the notice that Doctor's Choice is not a claim as per regulation 10.2. It's only a trademark. And then they say that it's a status on action on unregistered trademarks, it is not within the purview of FSSAI. Then this was the third complaint. Then the fourth complaint, here, FSSAI records compliance. That you'll also find at 3. Paragraph 2. In this regard, this office by regulator as earlier informed CCPA, this is the Consumer Protection Code, that the matter had already been examined and referred to the concerned licensing authority, with request to scrutinize the same further vis-a-vis the provisions of FSS advertising and directs the MPO, that is the petitioner, to ensure that all the claims are made in line with Schedule 2. Further, it is informed that the concerned CNA has issued the improvement and closed the case since the FBO has complied with the said notice by removing all the misleading claims from the adversary as well as from the label.
So confirmed.
Okay, so matlab this is matlab action taken. Now matlab this after, thereafter matlab you'll also next see matlab an affidavit which is filed matlab in the writ petition that was earlier filed by Mr. Mukherjee's client. That's at page 404. This is matlab their representation report.
Yes.
Look, this is affirmed on behalf of the FSI by matlab the assistant director technical. And matlab please see paragraph 4. Matlab this is the allegation that was made by Mr. Mukherjee's client. Now matlab very important paragraph 10. That paragraph 10 sets out whether the provisions of the general principle. Now, the general principle is very important.
Yes.
Well, this is what the authority says. The regulation portion of the food safety and standards that and well as there, you know, see that 7, because these are the general principles on which the authority relies. Whereas the meaning of a trademark, brand name, or fancy name containing adjectives such as natural, fresh, pure, original, traditional, authentic, genuine, real, appearing in the labeling, presentation, or advertising of food is such that it is likely to mislead the consumer as to the nature of the food. In such cases, a disclaimer shall be mentioned prominently on the front of the pack of the label stating that this is only a brand name or trademark or fancy name and does not represent its true nature relevant for the product. Provided that the front font size of the disclaimer shall not be less than 1.5 millimeters for 50 display panels and up to 100 centimeters, not less than 2 millimeters for principal display panels. It is submitted that as per the FSSAI letter dated it was already submitted that the concerned CLA had issued the improvement notice to Virtual Refinery and closed the case since FGO has complied with the said notice by removing all misleading claims from the advertisement as well as from the label and had also submitted a copy of the rectified label. FGO had provided the disclaimer for trademarks as prescribed under the above-mentioned regulation. Case closed. But what is the authority relying on? It says that when the ultimately the general principles govern. What are the general principles? That if you today clear or remove the confusion that is like to state, then there is no problem. Because it is not out of the ordinary for products to seek to facilitate sales by associating them with other common words. Now, I had on the last occasion handed up to your lordship the number of products which uses the stethoscope, heart, etc. And your lordship will remember, Imami markets and oil saying healthy taste. So these are associated words which are used, but they all come with disclaimers.
Yes.
And what is important is that ultimately the authority accepts that regulation 47 applies. If an improvement is made, if the confusion is removed, then there is no problem. Now, thereafter, this matter was also taken up by thereafter this affidavit was filed in the pending writ petition that your lordship will find at page 368. Now, your lordship has seen assistant director technical files and affidavit. Then at page 368 in the prior writ, the joint director food safety standards authority filed an
Yes.
That paragraph 6, page 370.
This is this affidavit and another one.
Yes, ma'am. This is in the previous petition that had been filed.
No, this 3405 is the earlier 20141. Yes. That is in.
This is the second affidavit.
Achha, this is okay. 20141 is the present.
That's it.
And this is the earlier one.
That's it.
Okay.
But this was in 460.
Yes.
And whether this is what they have been said by the joint director, so that the authority to add item.
Yes.
That there is no subsisting scope for confusion.
Yes.
And then paragraph 6, but then paragraph 7, then well, paragraph 8 is more important, paragraph 8 and 9.
Yes.
It is further submitted that in compliance with the agreement, FBO had already rectified the product label as directed and submitted copies of the rectified label. Additionally, the FBO also provided a disclaimer regarding the trademark. It is also pertinent to submit that subsequent to the compliance effort, respondent FSSAI received the communication from the Central Consumer Protection Authority by email dated such and such, seeking updated information on the matter. It is submitted that in response to the CCP's inquiry, the respondent FSAI furnished a reply dated 23rd January, comprehensively addressing the concerns raised by the petitioner and provided relevant details of action taken. The rest of it, I don't want to trouble your lordship. Now, the CCPA will take the matter up for consideration.
Yes.
Now, the CCPA's order, lordship time, proceeds on the basis of the report filed with FSA, that's at page 125. Then please see page 126. Well, reproduces regulation 47 again.
Yes.
Well, 47 is a part of the general principle.
Yes.
And 47 says that in this case, if there is something which creates confusion, we shall issue a disclaimer.
Yes.
Then paragraph 5, in view of the above, CCP observed that the alleged misleading advertisement published by the opposite party contained no such disclaimer for the brand name Doctor's Choice and therefore was misleading. Given the above, CCP issued a notice to the opposite party. Then, paragraph 7, opposite party submitted response. Paragraph 7, Roman 3, you'll also see. Further, this is the response. Opposite party have been using the trademark Doctor's Choice in commercial market for edible vegetable oil without causing any confusion, deception to the consumer. Just a writer here to add, 1999 onwards, no complaint, either by the consumer authorities or by the FSA. The term Doctor's Choice is distinctive, non-descriptive, does not convey any distinct idea about the kind, purpose, or the other characteristics of the product. Then 3, further Doctor's Choice product labels include a disclaimer stating that the name Doctor's Choice is the brand and not the true nature of the product, and stated that this is in accordance with regulations set forth by the FSA. Then next, the inclusion of the disclaimer of the product package ensures that there is no scope for misconception. Then next, however, the opposite party has edited their application and incorporate a declaration that will be prominently visible. Well, this is stated, I don't know further, Roman 8. And then it further says, hence, based on the so-called notice, the opposite party will be incorporated to the following recommendations in the advertisement to remove any further confusion or ambiguity. And what is it? They say the recommendation includes regular exercise of balanced diet, etc. etc. So ultimately exhorting the public to maintain a balanced diet and healthy lifestyle. Now, if you also see paragraph 11. Paragraph 10, as per subsection 2 of section 19 of the Act, where after preliminary inquiry, the central authority that the matter is to be dealt with by a regulator established under other laws of the land course, it may refer such matter to the concerned regulator along with the people. Given the submission made by the opposite party, a letter was sent to the FSSAI to obtain their comments on the matter to enable CCPA to seek certain required information. Reply of the FSSAI dated 6 July 2023 was received stating that if your lordship see, again references to regulation 4 or regulation 7, and it says at the end of paragraph Roman 1, then the FBO must get disclaimer. And what the disclaimer should state is also mentioned. Then we lordship kindly come to Roman 6.
FSSAI referred the concerned central licensing authority or designated officer with a request to scrutinize and further back and direct the FPO to ensure that all claims should be made in line with Schedule 2 of the said regulation. And the
So
claim is
CCP had decided this.
And then, my lord, here, on 8 January, a letter was sent to the FSAI to inquire about the updated status. And FSAI submitted a letter saying that the concerned licensing authority had issued him to Bajbat and closed the case since FPO has complied with the said notice. And then, my lord, after noticing that, please see paragraph 14. Well, it records, my lord, the FSAI response.
Yes.
And well, in paragraph 10, here are 260. The Central Consumer Protection Authority never following direction. But with respect to brand name Dr. Choice, kindly note the use of the brand.
Has to display the disclaimer.
Display the disclaimer. And
Not less than 3 mm size, appropriate size. This is only the brand name of the. So you're complied with.
Yes, yes. That has been done. Now, my lord, what happens is, my lord, when the earlier petition had been filed, they were saying that look, the FSSAI is not acting on our complaint. That is, Doctor's Choice brand is seriously misleading. Well, the FSAI comes and files that affidavit saying that they have complied. Well, then the court says that I'm disposing of this writ petition because nothing survived. Of course, if you want to challenge the order passed by the FSAI, that's up to you. So the second writ petition is filed. In the second writ petition also, the FSAI comes and files that report. Well, then at that point of time, Mr. Mukherjee argues the matter and says that look, a brand name will not protect the misleading activity. Well, at that point is something that we accept. Well, for example, Mr. Mukherjee cited the case of ORS. Well, this is oral rehydration salts. Well, when there's severe, heat waves, everything, dehydration happens, then we all have these ORS. But the problem was that under the heading ORS, there were certain brands that were being ultimately sold with the caption ORS, which were very high on sugar. And that was creating problems, particularly in young children. So the court said that ORS is a non-proprietary mark. No one has any claim or proprietary claim on that mark. And so therefore you can't use ORS randomly across the board. And many manufacturers. So that is what the court sought to restrict. Now here what happens is when that judgment is cited, then suddenly this is what the authority does, and that is the subject matter of challenge, the present situation. The Lordship will now see the constituent notice, page 398. This is what we challenged. After the assistant technical director gives his report, the joint director gives his report, please first see who issues this notice. This notice is issued, you will find at page 400 by the designated officer, Central Licensing Authority. You can't ultimately blow hot and cold. There is no power of review under this act. An order recording satisfaction that a complaint has been ultimately addressed, necessary improvements have been made is final. It cannot be revisited. Now, here is what my letter do. Please see this. Please see without any reference to the prior satisfaction notices, compliance orders, representations made to the CCPA, order of the CCPA. It is observed from the referred website and various front of pack labels of health insurance marked under the brand name Doctor's Choice by Bajbat Refineries that several misleading claims and advertisements are made, which are in contravention of the FSSAI 2.6 and regulation. In this connection, you are served with this improvement focus on 30. Now, the grounds for improvement, monetary interest. First down, your Lordship will see the brand name Doctor's Choice upon all the products and pictorial representation part may lead to infer that the product is heart-friendly and recommended by doctors. This is the subject matter of the previous notice. This is already something that's addressed. And they say immediately take corrective action, immediately desist from using the brand name. So ultimately, the object is to stop my trade.
Yes.
With the brand name Doctor's Choice, which has gained popularity since 1999. Well, one does not have to really stretch one's imagination much further beyond this to understand why this is happening. Well, today, in the marketplace, competitors are trying to really grab a share of the market from each other. Well, then the next, the claim goodness will the number one choice of the website. Well, it undermines the product of other manufacturers. I don't understand. Undermine the product of other manufacturers. How can that be the concern of the FSSA? Then 3, the terms purest doctor's choice Kachi Ghani Tel, bring home heart-friendly rice bran oil and bring home pure health soybean oil, refined oil, appearing on the product pages within website. Well, this is not on the label. This is on the website. And you'll also see, the claim goodness delta is also on the website, not on the label. So label is only brand name doctor's choice. Then 2 on the website, 3 on the website, 4. The claims of lowering cholesterol levels, supporting heart health and effectiveness. This is a frequently asked question. Answer is the refined brand oil page. The claim that doctor's choice refined sunflower oil is ideal for heart health conscious redefined rice bran oil. Now, let's pause here for a moment. But your lordship is seeing advertisements everywhere, which basically says that today, mustard oil, the sunflower oil is the better choice. Soybean oil is the better choice. And all of them are ultimately geared towards assuring the consumer that if you have this oil, it will not damage your heart. On the contrary, this is a healthy choice. Because the oil is a part of our daily lives. Well, it can't be ignored altogether. We are all concentrating on lesser oil, but not irrigating it. And you also see, this is how the market responds. Sun drops, hardship. So it is ultimately everyone is trying to show that this is hardship. It is not something that you also will consider that it is only I am trying to. Ultimately, it is not a misrepresentation. We are all trying to puff our product. We are all trying to say this product is good for the market. But there is no other attempt to undermine any other product or to say this is the only product which is the doctor recommends because there is this claim. Now, these 5 claim that doctor's choice refined sunflower oil is ideal for the heart health conscious.
No, with regard to the one, the brand name doctor's choice upon the doctor choice has not been given effect. On the brand name, doctor choice has not been given anything. Only upon all the products and the pictorial representation of the stethoscope in the shape of the heart, which may lead to infer the products is heart friendly.
The brand name doctor's choice upon the product and pictorial representation of stethoscope in the shape of heart.
But immediately desist from the using of the said brand name and the pictorial. And the pictorial. Okay.
They want to ban it. And this is exactly the subject matter of the previous notices, subject matter of the previous rectification order. And this is exactly on what now, both the FSSAI has recorded its prior satisfaction along with the consumer protection authority. Then the question is what was the substance for issuing this notice? There was no change. When the matter had come up for consideration at the time of or the time of this movie, then the question the judge asked what is new? There were previous notices, 4, 5, 6 notices that were issued. What is new that has prompted you to issue this notice? And in this particular notice, what is the new subject matter which for the first time features in this notice, which was not there in the previous notice? Well, I do not want to ultimately rely on this order because your lordship is hearing the matter back. So interim order is not of no concern. But I only want to show one submission that my learned friend made in court at the time. This they had already handed it up to your lordship, but I'll just hand this up. So this is the interim order. Kindly, be assured that I'm not relying on this interim order except for the one submission that was made by my learned friend. please see paragraphs 4 and 5. I'm sorry, paragraph 5. Only paragraph 5. She further submits that the allocations contained under serial number 7 of the notice dated 15 December 2025 was not part of the allocations contained earlier. So this is according to them the only new thing. I should not read the rest of what conclusion the single judge drew at the moment. I only wanted to show you that one paragraph, that their contention is that the only thing that is new.
So as per your at that point, the para 7, they are agreed with the para 7. Now, not agreed, they are telling the para 7 is the new one.
Now, what is paragraph 7? Please come back to page 399.
Frequently asked
The
question.
frequently answered question. This is on the website, not on the label. The frequently asked questions and answered in the refined soybean oil product page. That is what makes Doctor's Choice cooking oil different from other cooking oil. That only Doctor's Choice provides affordable product. It is not cut with cheap substitute. But they said this violation is regulation 10.5. I should take the logic of regulation. Such claims which give rise to doubt or suspicion about safety of similar food or which may arouse fear shall not be made and the said claim shall be made. With the greatest respect, this is something that every product says rely on this blindly. We are saying that we do not use cheap substitutes, but manufacturer not allowed to say that. We use pure ingredients. Now, one can understand what prompted this whole exercise. Now, thereafter, even that FAQ was removed. We want no confusion. Now, what happens is this presented petition. Oh, I'm sorry. That FAQ is not removed. I'm instructed that if necessary, if your lordship likes, we can remove that as well. Now, what is very important now is when I file this writ petition and your lordship direct affidavits to be filed, unless the FSSAI files an affidavit.
How much time will it take, Mr. Shah?
It will take a little time because I have to deal with the other case of I must confess, your lordship has also kept it for tomorrow. I will very embarrassed because your lordship fixes and takes up matter. But tomorrow, a situation has arisen for which I just cannot be.
Tomorrow you will not be available.
Okay. Lordship permits another date, otherwise my junior.
Another date कब होगा?
I know that that's why whenever I make this fair, I personally make it fair. I will now not come back here. I'll go to the regulations and then to Mr. Mukherjee.
Yes, because you completed your case, whatever the grounds. Now the second the first petition of the.
That I'll deal with and Mr. Mukherjee. I'll show you what affidavit they filed in this.
Yes. क्या है डेट है कुछ? दो डेट है? देखो है सितंबर. ब्लैंक करके रखो ना. 29, 30 September.
The hearing order is tomorrow.
Then counsel for the petitioner in WPA 20141 of 2026 has argued the matter, and no, 29273 of 2025 has argued the matter at length, but due to paucity of time, hearing could not be completed. The matter is already fixed tomorrow, but Mr. Shahan, a senior advocate appearing for the petition, is having some personal difficulties. He prays for deferring the hearing tomorrow and fix another date. He further submitted the interim order is till tomorrow and wait for actions and consider the submission made by the counsel for the petition. Let the matter appear on 29 and 30 September 2026 at 12 noon Interim order is extended till 30th September on.
Can 7 was the application for extension.
Can 7 is disposed.
Because reform need now legal matter. Because it is.
There is no decorum, there is no time. Whenever you persons feel, come with the mentioning. What is the urgency?
The writ petition to be filed.
Writ petition, what is the urgency?
This is record and marriage certificate is not granting.
So marriage certificate, what is the urgency on?
My property is in Netherlands.
Ah,
My marriage certificate is necessary. My husband has expired in there.
ah.
It should be
When he expired?
in December 2026.
Ah, December 26. Hmm.
Now they are asking for the marriage certificate because my service benefits of my husband and the property is there. For that, marriage certificate.
So what is the urgency in that?
I cannot get that.
Huh? Okay, you file it and mention it. What is the urgency?
So loss is
Why leave?
because the service is reforming legal.
So apostille is there.
There, but
So
the minor certificate. There is no problem. I see the last figure.
where is the apostille? There's no apostille. Where is the apostille? It's a notary. Where is the apostille? By the commission. You have to get the apostille from the embassy.
But that will take time. That is the
So,
reason- that is the reason why I released
that no, sorry, I will not allow.
Okay, 1 or 2 months.
Get it apostille. Yes.
Matter, FIR matter, 179.
Thank you.
What is the name? BISW? Where it is written? Cost title of the writ petition. Cost title of the writ petition. So H will not be there. BISWAGIT. H is to be deleted. We got an order. The petitioner press for leave to correct the name of the writ petition in the cost title. He submit that but in your appeal also it is there. In appeal in the first where is correct? Can you see, come to the page 28? Serial number 6. Serial number 2 is correct. Counsel for the petition submit that the press for leave to correct the cost, correct the name of the petition in the cost title. The petition, the land council appearing for the petition submit that the actual name of the petitioner is BISWAJIT. Ray, R-A-Y, Ray. R-A or R-O? ROI. Then again you kindly come to the page 28, the first Biswajit Ray, and how your appeal will maintainable? Kindly come to page 28. Biswajit is correct, Ray, and then it has been Ray, R-A-Y. And kindly come to the clause 6, ROY. So what is ROY or R-A-Y? Where is our Aadhaar card? Where is the birth certificate? Biswajit Roy. क्या बोला? Correct name is Biswajit Roy. BISWAJIT. Biswajit Roy. But In the cost title of the petition, it is recorded Bishwajit, Biswajit Roy. If consider the submission made by the counsel for the petitioner, petition is granted leave to correct the cost title and correct the name of the petitioner as Biswajit Roy instead of Biswajit Roy in course of the day. But you are disposed of. Just you correct it. Next. Disposed of. Disposed of. Yes. Disposed of. Next. Disposed of.
Page number 40.
Disposed of. Disposed of. Disposed of.
I'm for the Union of India, Lordship.
You give the name by mentioning the serial number. Disposed of.
Grateful, Lordship.
Disposed of. Disposed of. Another. Who is another? There are two persons. Who are they? Disposed of. Disposed of. Disposed of. Yes. This 24. No. 24 is appeal. Yes, appeal. In the Bangla language, to whom you have submitted? Disposed of. 194. Disposed of. 195. Disposed of. 196.
Page number 29.
Disposed of.
197. Page number 30.
Disposed of.
198. Again, page number 30.
Disposed of.
199. Page number 32.
Disposed of.
120. Page number
Disposed of.
101. Page number 47.
Disposed of. Disposed of. Disposed of.
Page number 42.
Disposed of.
105. Number 25.
Disposed of.
106.
Assistant teacher? So what happened? Yes. So what you want? Oh, appeal disposed of. Where is the appeal? Disposed of.
107. Page number 76.
Disposed of. disposed of. Under adjudication, record karo. The petitioner submit that the case, ache adjudication, disposed of. Adjudication लिख दो. Disposed of. Written disposed of. 211 disposed of. Who is appearing? Disposed of. Yes. 200
Case number 27.
disposed of.
21.
Disposed of. Disposed of. And others. How many persons are there? How the others? You hear? Yes, petition number 1. Son of petition number 3. And what was 2? Where is that? What? Counsel for the petitioner submitted. The petitioner has filed the present application praying for a direction upon the tribunal for disposal of the appeal filed by the petitioner before the appellate tribunal. He submitted pendency. In the meantime, the appellate tribunal has excluded the name of the petitioners and disposed of the appeal without giving an opportunity of hearing and without any notice. Counsel for the petitioner prays for a direction upon the tribunal for restoration of the appeal and for disposal of restoration of the appeal, and after giving an opportunity of hearing to the petitioners to dispose of the said appeal. Consider the submission made by the counsel for the petitioner for the interest of justice. Petitioner full stop. The appellate tribunal is requested to restore the appeals of the petitioners and to dispose of the same as early as possible, preferably within a period of 3 months from the date of issue. Yes. Same. Yes, next. Appear.
280, I'm on behalf of the petitioner lordship. While pending the matter, his name has been included. It's showing included on the portal, but supplementary list yet not been published.
Yeah, dismiss as in practice. Next. Yes. Which one? 220. So what happened, student? Which class? So he's pursuing the study, na? No problem. Yes, next. Yes. Disposed of. Disposed of. Disposed of. 125.
cancellation of SC certificate, but refuse to accept online bidding. I have shown
This is not the SIR matter.
it.
इसको क्यों?
August last week of August online portal stop. People
No, it is not the SIR matter ना. तो इसको एक काम कर, कल उसको मैं उसमें ले मैं कल पर जो है 27 तारीख को जो है ना मैं 10 मैटर्स में कर दूं. Yes, next. Yes, next. Disposed of.
27.
No, let the Mr. Shah argue. देखो दो तीन तारीख को है 5th and 6th September, October. 5th and 6th कौन लिया था? 5th and 6th October. Interim order is still 5th and 6th October. Interim order is till 9th October.
Due to another circumstances, complete disable lordship, Lord, on 21st Lord, so to pass an order to direct return to it's not really to submit his report, Lord. So
Which one?
Reported, Lord. No difficult on that.
Which one?
Lord, that was on Lord 21st, Lord, because I have to comply with your lordship, so that there is a mistake, Lord, as I have Lord understood, Lord, that it has been recorded. My submission is concerned, Lord, that the copy of the witness has been supplied to the petition. That's what I have to file a report, Lord. My humble submission is before lordship, Lord, that the copy of the witness, according to us, confidential document, we have not supplied on. That's for some.
So that's why you filed the report. It is a confidential. That's why you ask. You have recorded.
That's good, my Lord, but I have been difficult with the Lord. Yes, little correction, even lordship, so please, my Lord.
Come tomorrow. उसको कल को to be mentioned में रखो for correction.
I'm grateful, my Lord.
Lordship, am I permitted to speak a leave?
What leave?
Leave. It's a SIR matter. However, it is a quite urgent matter.
What is
as the
urgency?
As a petitioner is a handicap.
हाँ.
Spurt. However, since birth he's a handicap, now he is unemployed and facing a lots of financial difficulty. In such financial difficulty, when he's supposed to sell his property, which is registered under the DSR, the DSR refused for the same, as his name has been deleted.
Correct.
As such, I'm praying for your Lord.
What is the urgency in that?
They have suffering from a severe financial.
So many persons are issue notice.
Okay.
70 rupees.
Item number 18. 18, Salik. Mampi Shaw. Okay, let me see.
Lord, we have served on Miss Sudeepa Banerjee, services copy.
হ্যাঁ হ্যাঁ আচ্ছা আচ্ছা এটা লাস্ট
Lord, all the matters were served upon Miss Sudeepa Banerjee. She was there in court, my lord engaged her. She has spoken to my junior that she would appear, but now I don't find her. Maybe she has missed it today. So
You are appearing for?
the
repetition.
petition.
For
And in
all.
her absence, yes, there is no point in moving it in her absence. My lord, if my lord gives a date next
Today
week,
she is not here. Today she came.
I don't know, my lord.
Since morning I didn't find her.
Lord, I shall contact with her. My lord may keeps it on any other day next week because there is no point in doing it in her absence, my lord. Because I believe,
It is a hearing, na?
Lord, it is on a question of law whether, Lord, the fourth schedule, second schedule and third schedule of the Right to Fair Compensation Act, Lord, whether the arbitrator appointed under the National Highways Act would be able to give benefits of second and third schedule. Because under 3G5, the arbitration that is to be filed, that says that it is only for enhancement of the amount awarded by Kala. Now, if the 13 Act is applicable, which is being done in every case as per 105 of the Act, it says that the benefit of second and third schedule should also be given. That's the question of law. So I will ask Ms. Srimani to contact Ms. Banerjee and will come back whenever your lordship diary permits. Because there is no point. কোথায় সুদীপা কোথায়? Union of India আছে তো। In all the matters, my lord may give us any other day as per your lordship's convenience. কোথায় গেল?
Though the
কালকে
matter is
legal cell
special
এর
week today at
appoint করেছে মহিলা
2 p.m. for hearing, but none appears on behalf of the
এটা দিয়ে দে জজ সাহেবকে।
recording case is adjourned.
My lord may keeps this service copy to your lordship's brief or I should prepare an affidavit?
Let the matter appear on 9th October.
বলেছি তোমার। She has arrived, but
9th October
9th October.
at 2 p.m.
My lord. No, I'm sure in September it will be very difficult for my lord.
Huh?
In September it will be very difficult for my lord.
Very full.
So many matters are.
There is a full.
This side of vacation is okay for me. পরের দিন একটু appear করে যে সুদীপা।
Come ready on that day, no adjournment. Yes, next.
Lord, I appear for the petitioner in this matter. Your lordship had called by the last order, your lordship had called for a report. This concerns, my lord, the registration of a reconstituted deed of partnership, which we had submitted, but there is no response from the respondents. Now, your lordship had directed filing of a report. We have got a copy of the report in court today from my learned friend. My lord, I had a cursory look at it, and it appears that the objections taken are purely hypertechnical, saying that some KYC is not there, it is beyond certain time limits in the Bengal Partnership Rules 1933, etc. My lord, I need to go through this before I make a definite submission before your lordship. My lord, what I was praying is your lordship will kindly keep the matter after about a week. In the meantime, my lord, I'll consider this, and if necessary, I may come up with an exception to the report.
Record or not. And counsel appearing for the state has filed report after serving the copy to and counsel for the petitioner. Counsel for the petitioner prays for time to go through the report, and if required, he will take exception to the said report within a week. Let the matter appear on 8th September.
8th.
Under the same meeting within 10 matters.
Lord, deeply obliged.
Next.
Because maybe added that first 10 matters if possible.
Within 10 matters.
Last
Yes, next.
8th, my lord, I am appearing on behalf of the petitioners. Yes, yes. Achha. My lord, seven petitioners are before your lordships. Petitioners are among the 179 flat owners of one housing complex under the purview of Apartment Ownership Act. And respondent number 2 is the competent authority, special secretary and competent authority. We are primarily on the non-adjudication of the complaint which we raised, being the petitioners, before the competent authority and the subsequent passing of the order, which as per our submission is illegal. From the very beginning, we aggrieved by the several illegalities on the part of the managers, including the very formation of the board. Now, my lord, our prayer is, without following the due process, the maintenance charges were arbitrarily increased. We lodged several complaints, including several complaints before the competent authority from page 120 onwards. We have annexed. Subsequently, we were brandized as defaulters, despite the fact that we continued to pay the maintenance charges. Now, my lord, we are being harassed. Our using of lift has been stopped. They are not allowing us to use the main gate. Mostly the essential services have been stopped. Subsequent to the filing of this writ petition, competent authority conducted the hearing and dissolved the board. Administrator was appointed. Now, who is the administrator? I'm asking myself. The administrator was already on the earlier board. He is the person has been appointed as administrator, manager of the earlier board. Now, what he did, he passed an order directing stoppage of the essential services. Yes, my lord. This is the affidavit of service. No one is there, my lord. My lord, shall I give them a notice once again?
When you served?
My lord. My lord, we are.
February. You served the press note. You are appearing? 3, 4 and private respondent. What about the authorities? Who has passed the order? Who is the administrator?
Well, respondent number 2.
2. He is not appearing. Jitendra Singh. D. Vilas Narase. Respondent number 2 is?
Respondent number 2 is Special Secretary and Competent Authority under the West Bengal Apartment Ownership Act.
Huh?
Kunta. Subsequent, huh? Well, until and unless they are appearing, my lord, how can we serve, my lord? But be that as it may, my lord, we shall serve them a notice along with the copy of the last order.
Affidavit of service filed with the petition be kept in the record. Respondent number 3, 4. 3, 4 and 5 are present. None appears on behalf of the respondent number 1, 2, 4. 1 and 2. Police stop. Counsel for the petition is directed to again inform the next date of hearing to the respondent number 1 and 2 and to file affidavit of service 1, 2 and 6 and to file affidavit of service on the next date fixed 5 and 6. 1, 2, 5 and 6. So 2, 3 and 4 bola na? 3 to 4. So 5, 1 and 6 and to file affidavit 1 and 6. 1, 2 and 6. 1, 2 and 6 and to file press affidavit of service on the exact fix. List the matter. Is a local? Here only. List the matter on 8th August, 8th September.
My lord?
8th September.
My lord, 8th September. All right, 8th September.
Under the same head.
But in the meantime, I shall serve them a notice only.
Inform the date.
Intimating the date. Well, we are serving right.
You file the supplementary, no?
Well,
not file the
supplementary. Well, we are affirming one supplementary affidavit. We shall serve them.
Because it is not on court record also.
No, no.
Yes, next.
I am for the petitioner.
Yes.
This is the third time came before the. This is the third writ petition filed by the petitioner. Petitioner is a senior citizen, old lady, my lord.
Petitioner is an old lady.
Yes, my lord.
Yes.
Kindly
come
come
to the, want?
Kindly come to the page 45 first, my lord. The first order passed by the Honorable High Court, my lord.
45.
Page 45, my lord.
Yes.
My lord, operative part, my lord. The operative part, my lord, the page 46, my lord. If the petitioner is of the view that the terms and condition of her gift to her elder daughter are not being met,
she may apply for appropriate remedies inter alia under the Senior Citizen Act 2007.
Sorry, my lord, I know, my lord. I'm disturbing the property. My lord, let the position of the earlier matter be retained. My lord, your lordship knows otherwise.
Within 10 minutes. Yes, next.
My lord, that my lord, thereafter, my lord, kindly come to my lord, page 54, my lord. She file an application before the tribunal, my lord, under section, my lord.
54.
Page, my lord, 54, my lord, annexure P9, my lord. Under section 23 of the Maintenance and Partners on Senior Citizen Act, my lord, 2007, my lord. My lord, kindly see the prayer, my lord. Kindly see, my lord, the prayer of this application, my lord. Page, my lord, 63, my lord. Page 63.
Declare the impugnated
Yes,
null and void.
Yes, my lord. My lord, they have not taken any steps, my lord. So, my lord, petitioner again file an application, my lord. Page 66, annexure P10, my lord, for application for expedited hearing of the said instant appeal, my lord. But they have not taken any step. Petitioner came to the again, my lord, High Court for, my lord, not taking any steps, my lord. So, my lord, the Honorable High Court passed an order. Kindly see, my lord, last page, my lord, 109, my lord.
109,
my lord.
9.
Annexure P13, my lord.
Yes.
When the matter was taken up for hearing, my lord, the learned advocate for the respondent, my lord, hand over a reason order, my lord. Reason order produced before the court, my lord, and this order was passed, my lord. Kindly see the order, my lord. Again, my lord, the private respondent assure, my lord, the court, my lord, they will, my lord, allow the petitioner, my lord, to enter into her house, and my lord, she will maintain her mother, my lord. But nothing was done, my lord. Again, she go to the house, again drive in, my lord, and my lord.
Where is the tribunal's order?
Yes, my lord. Yes.
Where is the order
Yes,
of
my lord.
tribunal?
107, my lord.
Huh?
107, my lord. And it's appeal. They have nothing done, my lord, only for kindly see, my lord.
Then?
My lord, I filed this writ petition, my lord, to cancel the order, my lord.
Why
because
why cancel?
Well, my prayer is
The senior citizen.
Yes, my prayer is
Senior citizen, this application filed by you.
Yes, my
In your application, the maintenance tribunal has passed the order.
Kindly see my prayer.
You're dissatisfied with the order.
Yes, my lord.
So you file an appeal.
Yes,
file an appeal under section 16.
My lord, she is a very old person, my lord. She is not able to, my lord, come to court, my lord. My lord, because my lord, her condition is very precarious, my lord.
Now I am.
Everywhere, my lord, they submit, my lord, but they have not taken any steps, my lord.
Page 46. After.
Yes,
the petitioner, and when they want the private respondent undertake before the court to take care of the petitioner. My lord,
So this order is passed in 2024.
Yes,
correct. December 2024. You have not challenged this order.
Yes, my lord.
Have you challenged?
I filed a writ petition, my lord. So, my
Petition, how the writ petition is maintainable? Kindly come to the section 16 of the.
they have not taken any steps. So, my lord, file a writ petition. In that writ petition, they have submitted.
If they have not taken any steps, go to the execution.
That appeal is that matter, my lord. My prayer is that another, my lord, they passed another order, my lord. My prayer is that, my lord, cancel the deed, my lord. Because my similar circumstances, Supreme Court has passed an order, my lord. My lord, cancel the deed, my lord.
Correct. Supreme Court passed an order, cancel.
I said order, my lord. Page 78, my lord.
Correct. I am just a recent order you have gone through.
Yes.
Just a week.
Yes.
A week before.
Yes.
A week before the Supreme Court has passed an order you gone through.
Yes, my lord.
Where is that order? A week before the Honorable Supreme Court has passed an order under section 23 of the Maintenance Citizens of Maintenance Act, Senior Citizen Maintenance Act. Have you gone through? No. Then, and how the writ petition is maintainable only because of.
I know, my lord. I know, my lord. This is old lady, my lord, he is no, nothing, my lord, he's not.
So every lady will come to the High Court.
My
leaving
lord,
aside the
daughter and mother, my lord, they have again, my lord, see, old lady, my lord, kindly see the age.
And why you're not residing?
No, they have not allowed, my lord. They have not allowed, my lord. Court, they have come to the court, SCO, my lord. I go to the, my lord, they have not allowed.
Special officer on my cost, my lord.
Where you are residing?
Yes, my lord.
Where you are residing?
My lord, second daughter house.
My lord, she is the king. My lord, she is the king. I want to project some document before your lordship under pressure. I have given some property to them. After this gift of gift, I am the eldest daughter. My lord, he has no son. Daughter. I am the oldest daughter, 36 years that my marriage was celebrated. Thereafter, even on my husband's army, I have given marriage to them. Thereafter, under their pressure, my lord, kindly see, I have given another property to my younger sister. Thereafter, one property to my second sister. Now they are trying to grab the property one after another order is there. My lord, kindly, I want to produce one document where the petitioner refuses not to take maintenance in the tribunal. And I, one after another prayer made before the authority, my lord, kindly. Third last. However, the petitioner was asked whether she needs any maintenance or not. Petitioner refuses any kind of monthly maintenance. Respondent party offered to provide monthly maintenance, take care of the medical expenses. In spite of that, I have given the medical expenses. My lord, this is the document. My lord,
Yes, what is your contention? What, tell me. Can I dismiss this writ of application? It is not maintainable.
Yes, that is, I bow down, my lord.
Then
that is admitted, my lord. There is a tribe appellate forum. Appellate forum, but
ready to give maintenance. I want to take
and
that
2024, how you find an appeal after 2 years?
during pendency of the writ petition, this order was submitted. The expert team, they're not in my presence, no notice.
So that's why before this court, you are submitted before this court, you will take appropriate steps in against this
Your
order.
Lordship, then my
Instead of
lordship-
preparing an appeal, you file the shortcut method of
Then
writ
your lordship
petition.
condone the delay, my lord.
Because
then-
filing a writ petition is very shortcut.
Yes, my lord. Then my lord, your lordship condone the delay, otherwise, my lord.
File
whole
writ
lady,
petition,
my lord,
220
where-
rupees.
where she-
220 rupees stamp, after 100 rupees Xerox, enough, and need not to, then advocate will take all the care, the petitioner, but before the appellate tribunal, you have to go and sit from morning to evening, then the case will call, if it's not called, they adjourn, then after 15 days it will come. So it is very easy, but the act cannot, does not provide, you can challenge the order. If you are not the senior citizen, okay, that it is maintainable, but you are the senior citizen. So for the senior citizen, that's why the parliament has make the rules for the senior citizen not to come
I
to the
admit.
court, go to the tribunal.
I admit, my lord.
Yes, what do you want?
Your lordship,
Tell me.
condone the delay. My lord,
What
to-
condone the
to
delay?
preferring the appeal.
How this court can condone the delay?
As
How
if
this
you-
court can
if
condone
your
delay?
lordship, there are some observation, my lord, so that they can condone
See,
it.
you all persons how you are misleading the clients, I don't know. And how the matter can be, how it can be condone the delay, kindly come to the page 107, that is the December 30th December 2024, the order was passed. And when you file the writ application, May 2025, what is the time period of the appeal?
In the absence of the petitioner, it order, petitioner did not know, my lord.
Okay, did not know. Where is the order of the Justice Sinha?
Page 109, my lord. Kindly see, my lord.
100?
109, my lord.
109.
Learned counsel for the respondent produce a copy.
So
Produce a copy. My lord, they have not communicated.
the
my lord.
petitioner has filed the present writ application challenging the order passed by the London Maintenance Tribunal, Constitution Maintenance Tribunal dated 31st of December 2024. This court find that the writ petition is not maintainable as the petitioner is having an alternative remedy of appeal before the appellate tribunal. Accordingly, the writ petition is dismissed with the liberty to the petitioner to prefer an appeal before the appellate authority. This court find that though the order was passed on 30th December 2024, but the order was not communicated only when the petitioner has filed the writ application on the earlier round of litigation being WPA number 8551 of 2025, the Landed Council appearing for the state has brought to the notice of this court to the impugning order dated 30th December 2024, and the copy was served to the petitioner. The petitioner, instead of filing an appeal, has preferred the writ application before this court on 7th of May 2025. Considering the above, the appellate tribunal, if the petitioner files an appeal before the appellate tribunal against the order dated 30th December 2024, the appellate tribunal shall consider for condoning the delay by giving the benefit of section 14 of the limitation.
Deeply apply, affidavit of serviceman.
Next.
Deeply apply.
Yes.
Lord, item number 10
Yes.
is my writ petition, my lord. My lord had asked, it had appeared on a previous date. My lord had asked me to file to serve and then
Yes,
disturb.
affidavit of service file taken on record, none appears.
I have served once again, my lord.
Then again now appearing.
Possibly my learned friend is
What is appearing?
He's there.
Who is the authority?
Lord, the Southeastern Railways.
Southeastern Railway. Southeastern Railway having group of advocates.
Possibly my learned senior is appearing.
You are appearing? Yes.
May.
What is the matter?
Lord, there was 3 awards.
Huh?
There were 3 awards.
3 awards.
Where I was successful in all 3 awards.
You are ready? So why you are not telling? You are appearing, you are telling. And seeing the face of the court. What instruction you required? When you come with the instruction. So you are having instruction.
Then may I move?
Then may I move? So you are having the instruction. Your only submission is no payment is required to be paid. Already paid. Show the document. I will dismiss the writ petition here in now. Show the document. He has received the payment or the bank transaction or the receipt. I will dismiss the writ petition. And if you say the cost, I will pay the cost also. So. Yes. London Council for the respondent affidavit of service filed by the petition be kept as a record, and council appearing for the railway authorities submits that the respondent already paid the amount. There is no due is pending. Accordingly, prays for time to disclose the document to showing that the petition has received the amount. Let the report be filed disclosing all the documents within 2 weeks after serving the copy to the council for the petition. Petition is at liberty to file exception to the report, if any, within a week thereafter. Leave the matter on 29th September.
Lord, may I seek for one additional line within
10 minutes.
Pleasure.
Next.
Very obliged.
That I am for the petition. This matter was heard by your lordships on the last occasion. That the petitioner, short prayer, is a victim of the petitioner, is a victim of a cyber crime whose entire account has been frozen by the bank authorities on the instruction of the police. Your lordship last occasion directed me to serve the notice that I have served. You are appearing for the bank.
State.
She is appearing for the state, but the bank as the main answering respondent here.
Who is the for the bank? Which bank?
Indian Bank. I have served personal lordship direction where there is service twice. Earlier served and now they also served personal lordship. There is some urgency, but I cannot operate my bank account. My business is standstill. I can satisfy your lordship. They are not choosing not to appear, my lord. in spite of specific representations to them also. In Jadavpur branch. Jadavpur. But its service is complete, my lord. Delivered, my lord, it shows. Second time was. And your lordship's order was also communicated along with the covering letter. কবে? 14 ঠিক আছে। Basic lordship. This is not the service.
Where is the service?
Well, that's the affidavit service. Second affidavit service I've just handed over to your lordships.
Yes.
But lordship, this is not the petitioner that has been served a notice upon duties at page 22. He is the owner of a jewelry shop.
Page
He sold
22.
page 22.
Yes.
This is the notice received from the station house water to the bank. Right, this my in respect of a cyber crime, my account number was directed to be seized under section 106 BNSS.
Which account you are having? Both State Bank and Indian Bank, both.
This is the Indian Bank, which was Allahabad Bank earlier.
Now,
Only.
page 22.
Page 22.
There are two banks.
No, only the Indian Bank.
Account number, victim bank, State Bank of India. Account number, beneficiary bank, Indian Bank.
Yes.
So you are the beneficiary.
Yes, yes.
5037, this is your account.
Yes, this is my account, my lord. But what happens, but I am the owner of a jewelry shop. I sold two jewelry to a customer. He paid something from somebody's account probably. But he is the main culprit. So I submitted all the video footage, CCTV footage and everything. The police, instead of apprehending the real culprit, issued the notice to the bank, by virtue of my entire account has been frozen. The amount that your lordship will find the invoices. I have also raised the invoices.
No, how much amount? What is the amount?
66,000. 22,000 once, 66,000. Your lordship will find that in the subsequent pages, page 24. 44,000 is one invoice in respect of one ornament. The invoice is there on record. And another amount is 22,000, 26,000.
Okay.
My submission is very specific, my lord. I have made representations to the bank authorities. Your lordship just kindly comes to one document, page 39. Even I wanted.
Where is the service to the this police? Police
But the
authority?
state is my landed is appearing. My landed
Or
is
not police, the local police.
But the states, the Potashpur, at whose instruction the bank was seized. The SH of Potashpur police station.
What is our instruction?
There is a matter pending before the lower court, Malan, HCM contact, and there is no involvement of the, there is a layer one beneficiary account is there where the amount has been lien.
So what is your instruction? The amount is lien.
There is no call.
On my part.
Now, what about the amount?
The amount has decided by the bank.
Decided by the bank.
So regarding the defreeze matter.
The main culprit is
What
to
is
be
the
apprehended.
investigation report? What about the amount?
That amount, subsequently upon realizing that was cheated and lost the complaint regarding that.
Cheated, lost complaint, case registered. What about the 66 amount? What the investigation come to know? Whether this amount is required or it has to be adjudicated, or the magistrate has passed an order for freezer, or the amount is not required for the investigation.
Magistrate did not pass any order yet.
So what is your investigation submitted? Charge sheet submitted? What is the stage of investigation? Give the report.
I have submitted the CCTV footage. Let the applicable culprit be apprehended. Then anything, everything will come out.
It is found, further found, which remains hold on the beneficiary account.
So 66,000 is the pending before the magistrate.
Let it be kept, otherwise the entire remaining account will be, let it be kept in suspense.
Petitioner has filed the present date application praying for a direction upon the bank for defreeze the account of the petitioner being current account number 503763711725 maintained with the Indian Bank Jadavpur branch. Counsel for the petition submitted that the petitioner is maintaining the above mentioned current account in the Jadavpur Indian Bank Jadavpur branch. Jadavpur branch. Full stop. On 24th of May 2026, the station house officer Potaspur, Purba Midnipur, has directed the bank for freezing of directed the bank that the account of the petitioner is involved with regard to the disputed two transaction of rupees 44,000 and 22,000. Accordingly, on receipt of the report from the police cybercrime authority, the bank has seized this, freeze the account, freeze the total account of the petitioner, due to which the petitioner is not in a position to operate the bank account, for which the business of the petitioner is getting hampered. The petition submitted, the petitioner has made representation to the bank authority as well as the police authority, but none of the authorities have taken any steps for defreezing the account of the petitioner. Accordingly, the petitioner has filed the present application. The petitioner has filed affidavit of service showing service of notice upon all the authorities, but none appears on behalf of the bank in spite of service of notice. The London Council appearing for the estate has filed the report wherein it reveals that on complaint of one Hirnamoy Pahari, the case has been initiated and he has filed the National Cybercrime Reporting Portal pertaining to the Potaspur Police Station, Purba Mudnifu, received a complaint from NCRRP portal lodged by one Mr. Hirnamoy Pahari. Accordingly, a case has been initiated. Mr. Pahari had filed a miscellaneous petition before the London Court of Additional Chief Judicial Magistrate, Contai, being Miss Petition number 106 of 2026, praying for refund of the amount of rupees 66,000, and the application filed by Mr. Pahari is pending before the London Magistrate for disposal. London Council for the petitioner submit that London Council for the estate submit that till date the London Magistrate has not decided whether the complainant is entitled to get the said amount, and as such, if at this stage if this court allow the petitioner to operate the bank account and the petitioner will release the said amount, it is not possible for the bank to recover the said amount. London Council for the petitioner submit that the petitioner submit that the disputed amount of rupees 66,000 be kept in lien, and the petitioner may be allowed to operate the bank account with regard to the pending amount and to continue to operate the business account so that the petitioner can run his business smoothly without any interference by the bank. Consider the submission made by the counsel for the respective parties. This court find that the disputed amount of rupees 66,000. The complainant who has lodged the complaint, he has already filed an application before the London Magistrate for refund of the said amount. The application filed by the complainant is pending before the London Magistrate. It is fine that the complainant is claiming only rupees 66,000 and the disputed amount is also rupees 66,000. In view of the above, the bank is directed to keep the amount of rupees 66,000 in lien and to allow the petitioner and to defreeze the account of the petitioner and to allow the petitioner to operate the bank account. Read petition.
Deep obligement. And the police authorities may kindly may be directed to apprehend the real culprit. I have submitted CCTVs and everything.
That is pending.
They are not. Police authorities asking you pay the money. Anyway, but I have deep reason for us.
But I am appearing.
My application
My lord,
Yes.
my lord, here what has happened, my lord, we are the trade unions, the workers of a company which is now facing an application under section 7 before the National Company Law Tribunal by a financial creditor. Now we have come to know.
So who are you? You are the
I am the
company.
workers union, the trade union, and we are the workers union, trade union of the company which is facing the insolvency proceedings at not yet admitted. Now what has happened, my lord, we have come to know that the financial transaction which is the subject matter of the proceedings, my lord, is basically a accommodation entry, and we have placed certain income tax orders which came to our notice and knowledge, which we have annexed in this petition, and we have also annexed that before the National Company Law Tribunal. Now, Lordship, in a proceeding before the National Company Law Tribunal, it is basically between the creditor and the debtor. So no third party intervention is allowed as a matter of course. But we have applied for intervention also. Now we have made this petition on the basis of the representation which we have made before the Income Tax Authority, which is at volume 2, page number 280.
Why before this court?
My lord, only because, my lord, only so that they can consider and
Income tax, how
rep-
this court, how the red petition is,
My lord,
determination.
my lord, we have made representation before the income tax department that kindly take necessary steps and give us the information so that we can place it before the tribunal to show that it is a collusive matter and a loan transaction based on accommodation entry. And that letter of mine is annexed at page number 252, my lord, volume 2. Kindly come to volume 2. I am only small prayer. I am only seeking that let them consider and
No, the income tax, this court is not having any determination.
Mala, income tax authority, Mala, they are having, Mala. Kindly see my representation, which is at page.
Yes, you go to the court and you take, how this court can entertain the
Mala, they are the statutory authority.
Maybe.
Now, Mala, I have given a representation before them. Kindly see page number 252.
Yes,
Now, I'm
principal
only
director
saying that
income
let them consider and give a response based on my representation. That's all I'm asking. I'm not asking them to make any finding or give. I'm
Maybe
only
whatever it may be, sir.
kindly see
Mr.
the
Sharma, how this court can entertain? Kindly see whether this court is having determination.
Lordship is saying because
Tax
of group 9. No, Lordship is saying because of group 4 and group 9.
It is not under the group 9.
I know that. Malab, what is that? Malab, there is no adjudication where the court is calling upon on the income tax.
Whatever it may be, but unless and until this court is not having.
Correct. But in the other matter, that can be taken up here.
Whatever, I am releasing it.
So that it can go before the appropriate bench. Yes, group 4 bench.
This court is not having the determination to decide the issue raised by the petitioner in the present application. Accordingly, WPA number 19151 of 2026 released from the list of this court with the liberty to the petitioner to approach before the appropriate court having determination. Yes.
13. I'm appearing for Union of India. Malad, this is here, Malad, the RBI is the customer. We have given our letter, the representation. Page number is
for what?
Malad, so that Malad, same Malad. Because there are two angles. Because the creditor who has applied before the tribunal is a NBFC. So, Malad, and the loan agreement, according to what information we have found, it is an accommodation entry in Hindi known as Jama.
Whom you have made the representation?
Malad, we have made that page number 255. 255 मिला to the principal director नहीं 255 I'm so RBI वाला दिखाओ ना मतलब 268 chief general manager department of supervision और एक होगा 268 my lord 268 and 269
chief manager department of Reserve Bank of India
and 269 same मतलब let them consider and
can't be, you have to go to the ombudsman.
Malay, I'm not making any complaint. There is no banking complaint.
Yes.
I'm only saying that they should, in discharge of their duties, find out because Malay, they have issued a circular. Kindly see volume 1. Malay, what has happened? They have issued a circular which is at page number 30, where they have given the high risk NBFCs who are non-compliant with PMLA. Kindly come to page 30. This is the circular which has been published by the RBI. My lord, in this circular, my lord, Lordship will find the name of the creditor at page number 33. Kindly come to page number 33. Second last entry, 5521, CL number 5521, second last entry at page 33, PG Commercial. This PG Commercial is the creditor before the National Company Law Tribunal. The order I have annexed at page 28. Now, this is an NBFC, and this NBFC, who is a creditor, is mentioned in the high risk NBFC non-compliant with PMLA. Secondly, my lord, we have also annexed the order. We have annexed, kindly come to page 35. There is another circular non-compliant NBFC list which has been published by the RBI at page 35 P4. Here also, here also, my lord, the name of the same creditor is mentioned. I'm just giving you the. I was briefed in the first matter, my lord, not in the second matter. So all my markings have gone in the first paper. Page number 36, my lord. CL number is 51516. Name of PG Commercial will be found in the somewhere just above the middle, PG Commercial, which is the creditor before the tribunal. So, my lord, now we have come to know that this loan agreement, which is made the subject matter of the tribunal proceeding.
So what you want?
I only want that they should
PG
give
Commercial has initiated the Section 7
against my, where I am a
Against
worker
you.
and I am a trade. If on the basis of a collusive proceeding, I am the trade union and the worker and the workers of the company who is suffering this proceeding, which is not yet admitted. So I've come at the.
So why against the trade union they have filed the?
No, I am the trade union of the company which is facing the proceeding.
You are the
trade union, members of the workers union, who are of the company which is known as the corporate debtor, which is facing the proceeding. The order of NCL tribunal we have annexed at page 28 here also. Gajmukh Vinimay is the company of which we are the workers. Kindly come to page 28. The order is annexed. PG Commercial. Page 28, ma'am. So sorry. P2. Kindly see the cost title in the matter of Gajmukh Vinimay is the company which is in the business of jute mill. Now we are the trade union workers of Gajmukh. Now we have come to know whatever documents and evidence we could lay our hands on, that this is a sham transaction and a collusive proceedings, and the loan agreement is also probably an accommodation entry, which in Hindi is termed in local language, is known as Jama Kharchi. Now we have made a representation to the RBI that kindly find out and kindly ascertain whether this transaction is genuine, correct or not. And they themselves, my lord, they have issued 2 notifications where the name of this same company appears. And then, my lord, we have annexed orders of the income tax tribunal, which is that.
No, the Gajmukh Vinimay Private Limited.
That is.
So how you are connected with?
I am the workers trade union of Gajmukh.
Workers trade union
Gajmukh. Of Gajmukh. So if Gajmukh suffers the proceeding, then it will be have great impact on us. The jute mill will be closed, my lord. We will lose our employment and livelihood. So we are the workers, the registered trade union of Gajmukh. Kindly see the cost title. Kunal Das. Number 2 is National Union of Jute Workers, a registered trade union. 3 is Rashtriya Chatkal Mazdoor Union. 4th is Nadia Jute Mill, and 5th is Jute Textile Workers Union, a recognized trade union. So if
you all are the trade union,
all trade union and the members,
all trade union been represented by only one person.
Yes, my lord, one person.
How it can be?
My lord, they have given a letter of, my lord, they have applied for intervention also. Similarly, authorization letter, page 27. Page 27, my lord, all have authorized, my lord. One person, Kunal Das. Page 27, the authorization letter is annexed.
National
20, annexure P1. P1.
Nudea Jute Textile. Yes.
Now we have annexed bank statement of the creditor, which is part of the petition before the NCLT, where the name of 4 entities are appearing along with Gajmukh, and those 4 entities, I will just give you the name. Those 4 entities have been highlighted by the statutory authorities, will be involved in round tripping and giving accommodation entries. We will find their names. We have set out the 4 names in the body of our petition.
So what is the prayer?
Prayer is only prayer, only one prayer. Kindly direct them to consider my representation in accordance with law. Prayer G.
Kindly come to B.
No, B and B.
Conduct the inquiry and investigation.
B, only G, my lord. Only that, my lord. That is, we all write that. Only is to consider and dispose of my representation dated July 9th, prayer G. My representation dated July 9, 2026.
Where is the P9?
P9 is at page number volume 268 and 269. So in accordance with law, kindly direct them to consider my representation within 4 weeks or 5 weeks, whichever his lordship that deems fit. 268, 269. They both are dated July 9. After waiting, my lord, we have come and filed this petition. 268 is July 9. And 268 and 269. And we have given this service proof that these letters were sent by speed post. That is at page 270 onwards. So only pray G to the limited extent that kindly they may dispose of our representation within a time-bound manner in accordance with law.
Two 268. What is the prayer? Where is your conclusion? Can it come? That is not complete.
Where is the second page of the letter?
Where is the second page?
Second page is
No.
not. Second page is missing.
So,
Myla, here, there. Myla, kindly come to 286. Myla, that is the full letter is there. I'm so sorry. 286, P9. 286 is the full letter and and 292. I'm so sorry, Myla. 286 and 292. I was actually briefed in the first matter. So all my markings are there in the first matter. The lordship has sent it to the other bench. 286 and 292. So let them consider and dispose of the representation, my lord, within a time-bound manner. And 286, lordship will find these 4 names, ABCD, Jinwani, Sharad, Alco. These are all involved in round tripping as per the orders of the income tax department.
So what this authority will do?
My lord, the creditor is an NBFC. And the RBI also has a lordship role. They have a supervisory role and they act as per the RBI direction.
Correct.
Now, this particular NBFC, who is the creditor, is if it is involved in round tripping transaction and those transactions are enforced before a court of law to obtain orders against a running jute mill and which will affect my livelihood and employment. If I get this information and if they act on the basis of my representation, then I can show that before the appropriate tribunal so that the company can be protected.
No. You wanted to shortcut. You wanted to install this section and 7 by filing the writ application.
No, in the section 7 is already pending.
Affidavit.
My lord, we have already applied under intervention in section 7.
Go and intervene. Why the court? Why the writ petition can intervene during the pendency of the 7?
My lord, I'm not asking for any stay of the proceedings.
Maybe. Why?
I am saying both are collusive. I am only there. I'm not asking for stay. Kindly.
Court will pass an order. Tomorrow you'll go to the tribunal. See, High Court has passed an order. Let the authority decide.
No, I'm not saying to decide. I'm only saying, my lord.
This court find that the writ petition is to be decided after exchange of affidavit. Let affidavit opposition be filed within 3 weeks. Reply within 2 weeks. List the matter on 6th of October. Next. Good.
Well, I am for the petition in this matter.
Yes.
When I made an application for the post of MMR, page 23.
You are a contact of MMRs.
MMR. Well, in respect of the Golsi police station, page 23. Thereafter, the application is pending. I made an RTI application. The reply of the RTI application is page 25. But this application has not been decided. Page 25.
TA Koris, I am to inform you that no action taken report is found with respect
Yes.
of your application. Yes, application is lying with the district registrar office, Purva Midnapur.
Your lordship, kind direct to consider my
Purva Bardhaman.
application.
Who is appearing for the state?
I have given a notice.
Where is your representation?
Page 23.
Page 23.
Madam.
When you made the representation?
Now this application was made.
There is no date.
Yes.
No date.
No date. But received, my counsel received
5 March 2020. That 2020 application will still remain in the department.
But that's why when I made the RTI application, they have given the reply. No action has been taken.
The grievance of the petition in the present date application that the petition has made a representation to the that is also not eligible.
District register.
Huh?
District
Register Purva Midnipur, Purva Bardhaman with regard to the temporary appointment of MMR and Kazi at Galsi district Purva Bardhaman. Full stop. Purva Bardhaman. Full stop. In spite of submission of the representation submitted by the petitioner, the authorities have not considered the representation submitted by the petitioner. Thus, the petitioner has made an application under Right to Information Act to know whether the authorities have taken any decision to the representation filed by the petitioner. The petitioner has received the reply from the Office of the District Registrar Purva Midnipur under Right to Information Act, wherein it is mentioned that no action taken report is found with respect of the application submitted by the petition dated 5th of March 2022, and the application filed by the petitioner is still pending before the District Registrar's Office, Purva Bardhaman. Full stop. Counsel for the petition submit that the petition has made the representation in the year 2020, but till date the authorities have not decided the representation submitted by the petitioner, and accordingly press for a direction upon the district registrar Purva Bardhaman to dispose of the representation submitted by the petitioner dated 5th of March 2020. None appears on behalf of the state. Full stop. Considering submission made by the counsel for the petition, none appears on behalf of the. Consider the submission made by the counsel for the petition, read petition disposed of by directing the respondent number 3, the district registrar Purva Bardhaman to consider and to dispose of the representation submitted by the petition dated 5th of March 2020 after giving an opportunity of hearing to the petition within a period of 6 weeks after receipt of the disorder. From the date of receipt of this order. Yes.
Lord, I beg to appear on behalf of the writ petitioners, madam. Writ petitioners are the senior citizens, my lord, and an owner, and where owner of G+1 storage building, my lord, subsequently is the owner of the first floor of the said building, being gifted the second ground floor to the daughter in the year 2025. The allegation is against the daughter-in-law, my lord, who is the private respondent herein. There are a series of, my lord, police complaints which has been made, and there is an application made before the tribunal, wherein the tribunal has stated that we have got no power of eviction. My lord knows whether in terms of section 4 of the act and in terms of section 2B, D and F, my lord, and there are plethora of judgment, including the division bench and of the Supreme Court, which says that the person who are in occupation of a property which belongs to senior citizens are mere licensee and can be evicted, my lord. My lord, will kindly come, my lord, to, my lord, the deed of conveyance which proves that I am the owner of the said premises. That is at page, my lord, 35.
You are the owner?
My lord, admittedly, I am the owner. The private respondent has bought a property, my lord, that is at page.
Who is the private respondent?
The daughter-in-law.
Daughter-in-law?
Yes.
Where is your son?
The son has expired. Subsequently, that the
sole son.
I have got a daughter also, my lord, whom I have gifted the ground floor of that property in 2025, and the trouble has started from there itself. One of the daughter-in-law has bought a property, my lord, that is at page 48, my lord, in the year in January 2025.
এই জাজমেন্টটা পারবো।
You are appearing for? State.
এইটা পারবো।
Who is for the private respondent?
They have explained.
Madam, may I put in my affidavit in reply, Malad?
Affidavit filed?
Yes. Malad, I only want my property back, Malad. Malad, I am staying, Malad, in roads. The difficulty is that gifting the ground floor to my daughter, my lord, and after that the difficulty has started. There are series of, my lord, will kind of those are in vernacular. The police complaints, my lord, starts from page number 122.
Where is there is no affidavit? No affidavit is on record.
Malad, we have put in our reply.
You find the reply. Affidavit in opposition is not.
Malad, kindly come to the order impugned. Malad, we are suffering, Malad.
Where is the order?
Malad, the impugned order, Malad, the order is at page 142. Malad, I will only show 2 lines from the order, Malad. Kindly see, Malad, the second paragraph, that is the order dated 11th of February 26. It is further noted that the petitioner have not sought any monetary maintenance from the opposite party in the present application, and the relief paid for is confined only to eviction. However, the eviction in the present circumstances does not fall
So
within.
you are challenging the order passed by the tribunal.
Malad, we have more or less, Malad, asked for eviction, Malad.
You have filed this.
Malad, kindly come to
application.
my prayers, Malad.
No, you are challenging the page 142.
Malad, that is the order which has passed. Malad, kindly come to my prayers. Kindly come to my prayers.
You are challenging this order.
No, we have not. We have separately come up, Malad. We have
What separately? What the
kindly
court-
come.
What the court will do now?
Kindly come to page 30, Malad. These are special circumstances, Malad, and High Court has power to bypass the alternative remedy. I will show judgment to that effect. Kindly come to prayer, Malad. Malad, I am only seeking for this for eviction, Malad, nothing more. I want my property back, being a senior citizen. Malad, and Malad, if it is in respect of alternative remedy, Malad, I am armed with judgment, Malad, which says, Malad, that the High Court has ample power to bypass that and grant me eviction. Malad, this is the division bench judgment, Malad, passed by this High Court, Malad. Malad, may I hand over a copy, Malad, to your lordship, Malad? This is a very small judgment, Malad. May I, Malad, place the judgment, Malad? Mr. Mukherjee Lanet, senior, may I place it, Malad? Mr. Mukherjee Lanet, senior counsel, appear for the appellant. The appellant is the wife of the respondent number 2 in the appeal and the daughter-in-law of the respondent number 1 to this appeal. The respondent number 1 in this appeal is the writ petitioner before the Honorable Single Bench. Mr. Mukherjee is aggrieved by the order dated 14 July 21 in writ petition such and such. The Honorable Single Bench inter alia, in noticing the fact that the writ petitioner respondent number 1 to this appeal is the exclusive owner of the flat in which the appellant has residing with her husband, the respondent number 2, has complied of ill treatment at the hands of the appellant. It has been also noticed that respondent number 1, being a senior citizen, is entitled to enjoy peaceful residence in his own house, and the status of the appellant as well as the respondent number 2 are not better than a licensee. In view of the above matter, the Honorable Single Bench has directed the local police to ensure that the appellant and the respondent number 2, respectively the daughter-in-law and her husband, are escorted out of the said flat and shall not enter into the flat without the written consent of the respondent number 1. Mr. Mukherjee submits that the Honorable Single Bench, acting in its jurisdiction, could not have evicted the appellant from the said flat, which is in the nature of a shared household. The direction granting police assistance is drastic and goes against the concept of providing shelter to the daughter-in-law in a matrimonial home. In support of his contention, Mr. Mukherjee has relied on such and such. On behalf of the respondent number 1, Mr. Mojumdar Lanet, senior advocate, takes this court to the order dated 26th of November 2019 of the presiding officer, Maintenance Tribunal, as passed in a proceeding under the Maintenance and Welfare of Parents and Senior Citizen Act 2007. Further, taking this court to the operative portion of the order dated such and such, Mr. Mojumdar submit that the Maintenance Tribunal has come to the clear finding that the respondent number 1, as a senior citizen, has a right to determine whom he will allow to reside in his house.
Correct. This is the catch. Tribunal has hold that she is entitled.
Yes.
But where is in your case the opposite?
Here, my lord, it has stated that there is no right to kindly
Correct.
see
So
the-
you have to challenge this order.
Kindly see, my lord, kindly see, my lord, we are, but these are all senior citizen person, my lord. My lord has power to waive it. My lord, again, my lord, we will go before the tribunal. My lord has, my lord, will kindly, my lord, there is another judgment which says, my lord, this is a pattern point judgment in respect of eviction. My lord, may I
I will not pass any order which will come as open gate to all the senior citizens to come this court bypassing the tribunal. It is my open mind. Why the parliament has enacted the act of the senior citizens?
Mana, that is in respect of maintenance. We are not claiming maintenance.
You went to the tribunal, tribunal has rejected
That
your
is there. Mana, that is there.
You challenge, not challenge that. You challenge and you come to the High Court. Then if there is a direction of the tribunal to provide something and the opposite party is not complying with the direction, yes, High Court can. I am doing that. This court is also doing that. But here you have lost the case before the tribunal. Now you are not challenged that order. Now you wanted the High Court can pass an order for eviction of the opposite party.
The observation is such, my lord. Kindly may I again take your lordship to that. Kindly see the observation of the tribunal at page 142. What is the observation, my lord? However, eviction in the present circumstances does not fall within the purview of the maintenance and welfare of parents.
So correct. You challenge before the appellate authority. Go to the section 16. Section 16, appellate authority.
But that is the reason, my lord, I am submitting, my lord. My lord has power to, my lord, bypass that.
Sorry.
My lord,
my order. I have decided in the writ application. So I can sit on my own order. I have decided.
সেটা বুঝতে পেরেছি কি পরে ঘুরে আসবে না অন্য দিন এটা জাজমেন্ট নিয়ে আসবে কারণ এইখানটাতে আছে আমি দেখেছি
I will give you liberty. Go challenge before the tribunal, and if the tribunal will not consider, come. Because the 16 is only for the senior citizen, not to the others. That is also decided by me.
16 is in respect of maintenance, my lord. Kindly see, my lord. Section 16 is in respect of maintenance.
Yes.
My lord, we are not asking for maintenance.
23? 23? If it is not 16, if you have not filed an application under 4 and 5, so you have filed an application under 23?
23 is in respect of void. Kindly see the transaction of the property to be void.
That's why. So you want the deed is to be declared null and void, and you have to be given the property.
No, deed, I don't.
If not also, you want the property.
I just want the first floor of the property.
Yes.
My ingress and egress has been stopped. I kindly appreciate, my lord. It is as G plus 1 story.
Who is for the private respondent? Their affidavit is not here. But here is no affidavit. Who is appearing? Huh?
Should I give another notice and come back?
Yes, give the notice. Let me hear what is his contention. The private respondent is not present. It is submitted by the counsel for the petition. I state that the private respondent has filed the affidavit in opposition, but the affidavit in opposition is not on record. The petition has filed the reply. Let the same be kept with the record. The petition is directed to notify the next date of hearing to the private respondent and to file a first affidavit of service. This is the matter on 9th of September under same heading. Yes, close.
Made it returnable on
9th.
9th. And we will intimate and come back.
Yes, let it come. We'll see to that. Which appellate side? Yes. Yes.
Your Lordship, may I have your kind not leave to mention a matter, Your Lordship, contempt application from an order of Your Lordship directing payment of occupational charges and arrears of rent. No payment since December 2025. We are praying for some precedence, Your Lordship. We will be praying for leave to serve the contempt application.
Not filed.
Filed, Your Lordship. It's appearing, Your Lordship. Is item number 160. We're praying for some precedence because we'll essentially be praying for leave to serve the contempt
Where I
application.
could give your precedence. Tell
Any
me.
day, because we'll simply be playing for just leave to.
Contempt application, there is no urgency. Yes. Huh? What? Marriage certificate? Marriage certificate cancelled by the Registrar General of Marriage. So what is the urgency? नोट कर दे नोट कर दो कुछ समय दे यस लेके नोट कर दो यस कॉल द लिस्ट
It has come up, Malad, at my instance. I mentioned the matter, Malad.
I
But,
will not take up much time, Lordship. My learned senior friend will also agree. The affidavits have been called for. The Honorable Division Bench has not interfered with your Lordship's order. The Honorable Division Bench has asked your Lordship to dispose of the matter upon exchange of affidavits. Lordship, I was seeking due to the pendency of the appeal, we did not file our opposition. We are seeking for 3 weeks time to file the opposition. Thereafter, they can file a reply. My Lord may
I
fix a
just
time
explain the
for.
situation why I mentioned the matter, Malad.
Here.
Malad, the order has been passed on Tuesday, Malad. Your Lordship again, Lordship's order of Malad 18 June, against which Malad we went up in appeal, Malad. Well, I had handed over the order on that day, but I took it back, Malad, since the Lordship was not having the file. If your Lordship takes Malad paragraphs 41 and 42, the 41 Malad frames the issues to be decided, and thereafter the direction is at page paragraph 42.
Yes.
So Malad, Malad, the direction is that if your Lordship kindly takes page 26 bottom. Malad, may I place that sentence, Malad? 26 bottom.
Yes, yes. No
The
problem.
decision of the speaker shall be operative for a period of 2 months or until further orders by the writ court, whichever is earlier. The affidavits have already been called for and shall be filed before his Lordship, if not already filed. Now, Malad, this direction was passed on Tuesday. Malad, your Lordship had initially given a time for 3 weeks for them to file the opposition. Malad, 1 week has gone by. They were in notice of this order, Malad. So, Malad, kindly gives them 2 more weeks, Malad. That was my submission. And your Lordship had originally given me 2 weeks to file a reply. Well, that may remain, but they may take further time. Well, I am not to oppose, but the direction is for 2 months. And if 2 months expires, Malad, the private respondent is to lose their status as a leader of opposition. Malad, I have no one to say anything with regard to that.
2 weeks also, sir.
2 weeks from today.
Yes, yes.
2 weeks from tomorrow. Yes.
2 weeks.
from
No,
tomorrow.
it is 2 months or until further orders. So there is already.
Whichever is earlier, not whichever is later. So
Yes, it can be a. But grants us 2 weeks time.
Record and order. In view of the judgment caused by the Honorable Division Bench in APOT number 110 of 2026, the Counsel for the petition mentioned the matter by an order dated police and Counsel for the respondents prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks.
2 weeks.
Within 2 weeks, reply it within.
Well, 2 weeks.
Within 2 weeks thereafter. Because I will fix if it is then because within 2 months it has to be disposed of.
Malad, kindly fix it after 4 weeks, Malad. Subject to Lordship business permitting, Malad, of course.
आज कितना तारीख है 24 देखो 28-29 तारीख को देखो खाली है 1 अक्टूबर है 1 अक्टूबर at 3 PM
1 October হয়ে যাবে হ্যাঁ এক মাস হয়ে যাচ্ছে
1 October at 3 PM
3 PM. Grateful to your Lordship. Grateful. না ঠিক আছে
Grateful. তোমরা বলবে তো?
Yes.
So this is
Argument.
argument of a suit. It won't take much time, my lord. This is that walking down the Park Street and finding the shop empty, that case. Lord, I'll tell your lordship in brief before showing, my lord, 4 or 5 documents. So this is again in respect of, my lord, the Karnani estate in Park Street. My lord, the suit as originally framed was, my lord, the defendant is Calcutta Carpets Private Limited, a company. So, my lord, I'll take your lordship through the relevant paragraphs of the plaint. My lord, the suit originally framed was, my lord, the tenant was an individual who was carrying on business, my lord, as Calcutta Carpets in the partnership. Now, my lord, this concerned person, my lord, he has expired long back. Now, they did not intimate the death of that person to us, and they continue to tender rent, my lord, in the name of Calcutta Carpets only, which was a partnership firm then. So, my lord, when we come to know that the original person who had taken the tenancy has died and there is no connection with the other partners there, and on top of it, it's now a private limited company. My lord, we framed the suit that they had suppressed the death of the original Hasmat Rai, and after that, my lord, the person in actual occupation is a company. So, my lord, they are trespassers, they should be evicted. In the written statement, my lord, my job has been made easy in the sense I need not go into all this. They are admitting the fact that there is no privity of contract between the defendant and the plaintiff. Number 2, they are going a step further. They are saying the defendant has become owner. How the defendant has become owner? By adverse possession.
Counterclaim filed.
Counterclaim filed, yes. Declaration, they have become owner as adverse possession. Now, my lord, how adverse possession? The case in the written statement is that the earlier tenancy, where, my lord, the father of the present incumbent, who is in control of the company also, after the death of the father, they had surrendered the tenancy and gone away. From 1980 to 1990, the property remained in vacuum. They do not know how things had transpired in the 10 years. In 1990, all of a sudden they come, they find that it is empty. This person and his brother again goes in and does business. And since they are there from 1990 till about 2026 or 2023, whenever the suit has been filed, so it is more than 12 years, therefore hostile. Now, my lord, the short point will be, for a possession to be hostile, number 1, you have to know who the real owner is, and you have to declare your title hostile to that of the owner. That is, to all and sundry, you have to say, no, so and so is not the owner, I am the owner. Here, my lord, lordship will find from the evidence 3 facts emerge. Number 1, he says, I did not know who the owner was. So, my lord, moment you say, in one breath, he is saying, I did not know who the owner is. On the second breath, he is saying, I am the owner. Because, my lord, these two are mutually destructive. If you do not know who the owner is, you can never claim a title to be hostile. Because I don't know who the real owner is. How can I claim a hostile title? So, without knowing the real owner, you cannot. And number 3, the most crucial evidence, their trade license shows that so far as Calcutta Corporation is concerned, they have admitted, or the predecessors had admitted themselves to be tenant under the plaintiff, and had declared that 300 rupees and odd was the rent. Because, my lord, the earlier trade license receipts, my lord, trade license can only be given if the landlord consents.
So my lord, landlord was consenting because we thought Calcutta Carpets, the partnership firm Hasmatra is carrying on business. And even my lord, the corporation receipt is mentioning 300 rupees as rent, which was then my lord, the prevalent rate. Now all these were confronted. My lord, the witness, so far as the defendant's witness is concerned, my lord, he takes a policy of admission and avoidance. Whatever is inconvenient, he says, I do not remember, I can't say. That is that. I'll show that. This is in sum and substance, my lord, the entire gamut of the facts. My lord, kindly takes the plaint. I'll show your lordship because I really don't have to trouble much your lordship much because of the stand taken in paragraph 3 of the written statement. Because now the burden has completely shifted upon them. They have admitted, now it is evident I am the owner, but they are saying they are the owner and they are in hostile possession. So the burden has completely shifted upon them. I have nothing because, my lord, once if they are unable to discharge the burden, decree is automatic. I don't have to show any of this. But be that as it may, my lord, just for completion, if lordship takes the plaint, it kindly comes to page 2, paragraph 2 of the plaint.
Yes.
At all material times and until such time hereinafter, Hashmat Rai and Ramchand were carrying on business in partnership under the name and style of Calcutta Carpet Store, hereinafter referred to as said firm, which was shop number 11, well, about 1100 square feet on the ground floor of erstwhile premises number 43 Park Street, presently part of premises 47 Park Street. My lord, earlier, my lord, all these, now it has amalgamated and has become part of 47. It was erstwhile 43. Now, my lord, para 3, we have a letter of 9 September 1957. Hashmat Rai informed the plaintiff that Ramchand had expired and was succeeded by his son Gopal Das and requested to change the rent receipts in relation to the tenancy of the said property in the name of the said firm, which was earlier being issued in the name of Ramchand Hashmat Rai at the firm so and so on the ground floor. Then, my lord, 26 November 57, Hashmat Rai with Gopal Das as partners of the firm along with others as heirs informed there would be no objection if rent receipts issued in the name of Calcutta Carpet Store. So, my lord, admitted position that from 1957, rent receipts were being issued in the name of Calcutta Carpet Store, which was a partnership firm and which had the partners of Hashmat Rai and Ramchand and his heirs. Ramchand dies and Gopal Das comes in. This is an admitted position. Then, my lord, straight away kindly comes to, my lord, para 5, I am not troubling your lordship. Whatever has been narrated, it takes the shape of a formal agreement of tenancy dated 10 December 1957.
So, when you change the name, because earlier it was a Ramchand Hashmat Rai.
Yes, my lord, it was changed. Kindly see, my lord, paragraph 4.
26
September. I'm sorry, paragraph 3.
Paragraph 3, 9 September.
Para 3 and then para 4. Yeah, paragraph 4, sorry.
Paragraph 4, 26.
Yes.
So, November 2057, you started giving carpet.
Calcutta Carpet instead of that.
Yes.
The name of the firm was Calcutta Carpet Store. Calcutta Carpet Store. And a formal tenancy agreement is also there, 10 December 1957. These all become academic because I don't have to trace anything now. Though, my lord, it's the same person. The son of Hashmat Rai is, my lord, the man who is carrying on business, my lord, as Calcutta Carpets Private Limited. But because of the case that he has run, I don't have to show anything of this. Then, my lord, para 7. I'm sorry, my lord, para 6. From time to time, the rate of rent since 1957 has increased and the last paid rent in relation to the suit property of the firm Calcutta Carpet Store
was for October 2019 for an amount of 3800 per month along with applicable taxes, which aggregates to 4,484 as would be evident from the last tax invoice issued by the plaintiff. No rent has been paid in relation to the suit property being a shop room on Park Street since November 2019. The suit property has also been shut for the last few years. Well, this lordship will make a note. The fact that it has been shut, well, the witness of the defendant was forced to admit that they have shut, they are not running any business from there. But what they are doing, they are generating invoices from another property where they are running a shop called Gyani's showroom. That is his business. He is running fictitious invoices from there and showing as if he is carrying on business there. I'll show that. Because when the summons was attempted to be served, the sheriff's report also shows door locked.
So this 2019 rent receipt admitted.
2019, my lord, we have proved it.
No, they admitted.
My lord, their case is, my lord, very drastic. They are saying we have never paid rent. My lord, if they admit the rent, they will admit the tenancy, their case of adverse possession.
That's why I'm asking.
They are saying we have never paid rent. We do not know who has paid rent. That is, my lord, I believe that will be the argument. I do not know. I believe that will be the argument.
Yes.
Now, my lord, paragraph 8 of the plaint. Upon inquiries by the plaintiff as to the whereabouts of the said firm and its partner to recover the rent outstanding, it transpired as follows. None of the original partners of the said firm are alive. The said Hasmat Rai had expired on or about 7 February 1991. The business of the firm Calcutta Carpet Store had been taken over by the defendant, which is a company incorporated on 9th May 1991. Copy of certificate of incorporation is annexed. Copy of memorandum of association is annexed. The memorandum of the defendant has been subscribed by one Prem Gyani and one Suresh Gyani, who are both sons of Sri Hasmat Rai. Well, kindly marks this. At present, the shareholders of the defendant are Sri Prem Gyani, Jyotsna Gyani, Ravi Gyani and Shreya Gyani. The plaintiff states and contends it would appear that fraud has been perpetrated upon the plaintiff by the heirs of Hasmat Rai in collusion and in connivance with the defendant, particulars whereof are as follows. Death of Hasmat Rai was never disclosed to the plaintiff. The fact that the firm is no longer in existence was never disclosed to the plaintiff and instead rent was being paid on its behalf till October 2019. None of the original tenants have any involvement in the suit property as Hasmat Rai expired in February 91 and there is no involvement of Gopal Das Ramdas being the son of Ramchand. There is no existence of the original tenant and the suit property is occupied by a trespasser. The defendant, which is a separate juristic person, has been in wrongful and illegal occupation of the suit property since 1991 and has been carrying on business in suppression of facts as above. But it was well settled that if a company comes in, even if the same person is there, it's a separate juristic entity and it would be treated as subletting or it is there. So, my lord, this is how the original suit was framed.
Yes.
Then, my lord, kindly come to paragraph 13.
Yes.
Because, my lord, we have pleaded fraud, that we were under the impression that the original Hasmat Rai is carrying on business and his death was never informed to the plaintiff. In fact, my lord, in evidence, the death certificate of Hasmat Rai is also not brought on record. We had given them opportunity twice because my lord, the date, either he has died before or whatever it is, they don't bring it on record. I'll show that. This is, my lord, we claim mean profits from 91 because originally, my lord, we could have gone 3 years before the date of filing of suit. But because, my lord, we have pleaded fraud and, my lord, they had suppressed this fact. My lord, we have claimed mean profit at this rate, and my lord, we have claimed eviction. Kindly see now the reliefs, page 8. My learned junior, my lord, wants me to place para 14, that is to save limitation. The Supreme Court, my lord, had excluded the period from 2020 to 2022. So therefore, my lord, no part of the, because of the pandemic situation. And fraud has been discovered only in 2019. Therefore, my lord, no part is barred by limitation. Paragraph 14, lordship will just make a note.
Yes.
Because admittedly till October 2019, we were receiving rent. Then, my lord, decree for the reliefs are decree for eviction, recovery of possession.
Why limitation? Why?
My lord, ordinarily, my lord, if a tenancy, my lord, against a trespasser, I can claim mean profit if
3 years.
only 3 years. But here, my lord, they have actually become trespasser from 1991.
Correct.
Because Hasmat Rai died in 1991, and even if I give them benefit of 5 years or 1991 and 96, because, and sorry, the company was formed sometime in 1991, this company. They suppress the entire fact.
Correct.
And because they suppress and they continue, I am continuing to issue.
That's why if you're telling that they continue and they paid the rent till September 2019, so your cause of action on subsequently you came to know. So cause of action arose from 19. If
No.
it is taken into
My lord,
19,
I am, that is why we have pleaded fraud. The fraud is that I have been led to believe that the original tenant is continuing from 1991
got it.
till 2019.
Got it.
That is the fraud. So I am compelled to accept 3,000 rupees on Park Street, right on Park Street, when I should have got, my lord, 3-4 lakhs at least, if not more. So this was the fraud. So therefore, my cause of action originally, my lord,
91.
the mean profit claim is from 1991, when a third party company has come in. Now, my lord, kindly takes the written statement. That, my lord, that makes it much more easier. That kindly comes to page 2 of the written statement. I rely upon paragraphs 3 and 4. Paragraph 3 is very interesting.
Denial the disposal.
With reference to the content of one of the plaint, it is denied that plaintiff is the owner. Now, my lord, kindly marks the next sentence. The defendant is the owner of the suit premises. So, my lord, it is now, my lord, instead of, my lord, a owner and a trespasser, it is as if the fight is between two owners. So we have the title deed. They don't claim to have any title deed. I shall show they claim title by adverse possession. And that, my lord, with respect, my lord, in law, the witness has been forced to admit they did not know who the owner was. If that is the case, no question of adverse possession. The next sentence, the order of approval of amalgamation could not have been issued by Kolkata Municipal Corporation or to the plaintiff inasmuch as the defendant, who is a co-owner of the premises, did not consent to the same. It is stated, my lord, kindly marks this. It is stated that the plaintiff used to be the owner of the said premises. The circumstances in which the plaintiff ceased to be the owner is stated hereinafter. So, threefold contention. Plaintiff not the owner, plaintiff used to be the owner, and the circumstances by which the plaintiff lost his ownership has been stated. Now, my lord, what is the paragraph 4? With reference to 225, it is stated that Hashmat Rai and Ramchand were partners of the partnership firm Calcutta Carpet Store until the time of death of Ramchand. Well, it kindly notes the death of Ramchand when it is not disclosed. After Ramchand had died, His son Gopal Das had become a partner of the firm. Hashmat Rai and Gopal Das continued as partners of the firm Calcutta Carpet Store, which was a tenant in respect of the suit property. So, my lord, up to here, plaint case and WS case is ad idem. The firm Calcutta Carpet Store continued as a tenant in respect of the said premises until the death of Ramchand in 1980s. Again, my lord, the exact date or year is not disclosed. Milord, I understand, Milord, my learned junior points out that the defendant in his deposition has corrected paragraph 4 and has said that this Ramchand should read as Gopal Das. I'll give your lordship the question. Kindly makes a note, my lord, this should read as Gopal Das, whatever it is. The firm stood dissolved thereafter. So, my lord, they make my case easier. That the firm in who was the tenant whose name had changed, it stood dissolved, it is no longer in existence. It was later that Prem Gyani and Suresh Gyani entered into the suit premises without the permission of the plaintiff or any other person and as owner on or about January 1990. Well, kindly see the inconsistency. If in paragraph 3 you are admitting that plaintiff was the owner of the suit property, in paragraph 4, assuming both the sentences are correct, it is legally impossible that if the tenancy is surrendered sometime in 80s, Milord, in 1990 you can enter the property as a owner. No question, you cannot enter. 12 years do not pass, assuming. In 1990 you cannot enter the property as a owner.
Correct. The firm stood dissolved.
So, my lord, the case is, my lord, mutually destructive of each other. One sentence destroys the earlier sentence. So, I read that sentence again. Upon the death of Gopal Das in 1980s, firm stood dissolved thereafter. It was later that Prem Gyani and Suresh Gyani, my lord, they are the sons of Hashmat Rai. Lordship can take it, and that is an admitted position. Entered the suit property without permission of the plaintiff or any other person and as owners on or about January 90. Plaintiff had abandoned the suit premises. Prem Gyani and Suresh Gyani did not enter into the suit properties as tenant in respect thereof, but they carried on business under Calcutta Carpet Store, a new partnership firm which they formed, and in spite of knowledge the plaintiff did not take steps to evict them or the defendant. It is the business of this new partnership firm or the business of Prem Gyani and Suresh Gyani carrying on business in co-partnership that vested in the defendant. Prem Gyani and Suresh Gyani as co-partners, and then the defendant from, kindly marks this date. The defendant from 26th April 1991 has occupied the suit premises as owners there. Right. Firstly, my lord, on the pleading, it is legally impossible for the defendant to occupy the premises as owner from 26th April 1991.
Correct.
Because even if their written statement case is deemed to be correct, let us say sometime in 1980s, well, the earliest date in 1980s can only be on 1st January 1980, not more than that. They don't say the date. They don't say the date even in the deposition. I'll show that. So, while 12 years therefrom will take them to 1992. So, no question of walking in or being owners from 1991.
Yes.
The firm Calcutta Carpet Stores, formed by Prem Gyani and Suresh Gyani, is a different partnership firm. The firm which was incorporated in 1990 by Prem and Suresh has never been a tenant in respect of the suit premises, nor it has ever paid rent to the plaintiff. Plaintiff is put to strict proof in respect of the statements. So, that is why
I don't have to show anything, well, they have made my task easier. They are not even claiming any tenancy. So my job becomes easier. But other than this, the only, well, I straight away take your lordship to paragraph 7 of the written statement.
Yes.
Which is at page 4. With reference to content of para 9, it is denied that any fraud has been perpetrated upon the plaintiff by the heirs of Hashmat Rai or anyone else in respect of the suit premises in collusion or in connivance or otherwise. Mala kindly notes the next sentence. The purported particulars are incorrect and are denied. It is denied that death of Hashmat Rai was not disclosed to the plaintiff. Kindly marks this. Because, my lord, here he does not even disclose or twice opportunity given his father's death certificate. Because, my lord, it was a double-edged sword. If he had it, my lord, he would have to show that he had, my lord, informed to the plaintiff. He said, my brother had it, I don't know, I couldn't find it and all that. I'll show that. But it is neither here nor there. Then, my lord, the next line. The plaintiff was then under the control of Chandra Karnani, who was a personal friend of Hashmat Rai and was always aware of the same. It is denied that the plaintiff was not aware or that it was not disclosed to the plaintiff that the firm Calcutta Carpet Store, which was the tenant, was not in existence. We are pausing here for a moment. Again, mutually destructive pleading. If you are saying that I have come into the property only in 1991 as an owner, how do you know what has happened to the erstwhile tenant?
Yes.
It is denied that the plaintiff was not aware or that it was not disclosed to the plaintiff that the firm Calcutta Carpet Store was not in existence. It is denied that any rent was paid after 1980 in respect of the suit premises. Gopal Das Ramchand also died in 1980. It is further stated there can be no existence of the tenant Calcutta Carpet Store, which itself stood dissolved upon the death of Gopal Das, and the possession of the suit property was handed back to the plaintiff. My lord, kindly notes. The suit property was taken by Prem and Suresh not as tenant. Even if no formal documentation in terms of the arrangement mentioned above has taken place, by reason of adverse possession, the defendant cannot be termed as trespasser. So, my lord, this is the only positive case they make up.
Yes.
Adverse possession. So, my lord, the first question will be, when did their possession become adverse? That for a person to set up a title or to justify possession by adverse, it can only be after they come in. Their written statement cases, they came into possession in 1991 as a owner. That I have demonstrated. It is legally impossible. If the earlier firm was dissolved sometime in 80s,
yes,
even if you take the earliest date of 1st January 1980, 12 years therefrom will only be after 1992. So you can't walk in as an owner. Now, assuming, my lord, the next limb is correct, you walk in 1991, then, my lord, you will have to set up a title. My lord, there are two things. Hostile title has to be set up.
Yes.
My lord, I read on further. It is denied that defendant can be said to be, my lord, I am at page 5, my lord, I am reading from the second line.
Yes.
It is denied that the defendant can be said to be acting in collusion with the heirs of Hashmat Rai or has concealed any fact, or that the defendant has any intention to deceive the plaintiff, or that any permission of the plaintiff was required to be obtained, or that the plaintiff is the landlord, or that the defendant in obtaining possession of suit property required any permission of the plaintiff as alleged or at all. The next line is very important. Prem Gyani and Suresh Gyani made over possession of the suit property to the defendant when the business was taken over by the defendant on 26th April 1991.
Prem Gyani and Suresh Gyani made.
But it doesn't make any sense. Prem Gyani and Suresh Gyani, well, they are the directors of the defendant. Now, supposedly the directors handed over possession to the company. That's what they are saying. Now, the only possible explanation is that, well, which well, the witness tries to come up in the box and make up is that Prem Gyani and Suresh Gyani again started a new partnership business under Calcutta Carpet Store, and then they handed over possession to the limited company. That's the only possible.
Because in paragraph 4,
yes,
they have made out a case that they both entered into the premises without the permission or any other persons as owner on January 90. So January 90 to 26 January 1990, April 1991, they were there.
So, my lord, there are three admissions. Prem Gyani and Suresh Gyani entered without permission, admittedly trespasser. Number one, because, my lord, earlier they have admitted my ownership, they have admitted. Number two, if Prem and Suresh are trespassers, the defendant who has been handed possession by Prem and Suresh, they can't have a better title or a better right than trespassers. And number three, the only case made out to justify their possession is adverse possession. So adverse possession is from when does it become adverse? It can only become adverse after you set up your possession as hostile to that of the real owner.
Correct.
Now I shall show from the cross-examination. My question was, you were aware who are the owners? He says no. If you are not aware who the owners is, then when I read on, this is the only paragraph which is of some relevance. Firstly, Prem Gyani and Suresh Gyani, and then the defendant have been in occupation as owners thereof, and in a manner hostile to the entire world, including the plaintiff. My lord, kindly marks this. Lordship will not find a single piece of evidence where this hostility has been evidenced. On the contrary, records disclosed by the defendant would show that they have described themselves as tenant, and the municipal records, the assessee number is also of the Karnanis, even of their latest license, the last possible license.
Yes.
Then, my lord, I read on. This would inter alia be evident from the fact that when the defendant carried on repair in respect of the suit premises in the year 2004, it obtained permission from Kolkata Municipal Corporation without any reference to the plaintiff. Well, I'll show that letter. A copy of the letter of 29 September issued by the defendant, a copy of the license for, this won't be obstruction, this should be, my lord, for restoration, for purpose of repairing, issued by Kolkata Municipal, are annexed here to and collectively marked. Certificate of enlistment in respect of the premises is in name of the defendant, not as a tenant and without reference to the plaintiff. This is completely incorrect. In cross-examination, we have shown, well, earlier certificate of enlistment and trade license refers as tenants. 300 rupees rent has been mentioned. Assessee number is my assessee number, and that we have confronted and shown. There has been several renewal certificate, copies of enlistment are annexed. It is denied it was ever suggested, so on. So, my lord, this is, my lord, the pleading. Now, my lord, Lordship will take the issues which Lordship will find in the order dated 6th November 2024 of your Lordship. 6th November 2024.
Yes.
But around 13 issues have been, my lord, framed because, my lord, they being the defendants, they had suggested, my lord, all these issues. But, my lord, I'll club these issues, my lord, the relevant, most relevant issues which will cover, my lord, number 2 will be very important because if the defendant is a trespasser, my lord, it covers issue number 1. And it also indirectly covers, my lord, issue number 3, because was the defendant or its predecessors in purported possession in open hostile so and so. So, my lord, 2 and 3 would be the relevant part.
Yes.
And then, of course, my lord, the other part will be, my lord, from issue number 7, whether plaintiff ceased to be a owner of the suit premises by reason of adverse possession. That is again, my lord, linked to issue number 3. If they are trespassers, no question. And issue number 9 is also interrelated. So, my lord, my lord, the first evidence which I want to show to your lordship, my lord, that is my title deed. That is Exhibit A. And there is no dispute with regard to that.
Yes.
Just formally, lordship will make a note. Exhibit A is my title deed.
It will take time, Mr. Chaudhary. It will take time.
But yes, lordship has another matter. Any date, lordship. Another one day, I finish it.
Counsel for the plaintiff has argued the matter then, but due to paucity of time, hearing could not be completed. This is the matter. अगस्त तो पहले नहीं, अगस्त कुछ नहीं, और उसके बाद कब है? 22nd September at 3:45 p.m. and 3rd October. 5th October at 3 p.m.
Deeply obliged. 22nd September and 3rd October. 5th October.
5th October. 5th October 3 p.m. 22nd 3:45. So you will complete then.
Yes, yes.
Coming back after a long time to trouble with this matter, my lord.
How many container?
My lord, 6.
6 container.
Not only one thing. In order to, my lord, encapsulate the matter in a very small, my lord, sphere, because your lordship had already passed an order so far as defendant number 6. So I need to, my lord, disabuse your lordship's mind so far as my facts against defendant number 10 is concerned. And how that is different from defendant number 6. Otherwise, my lord, the same observations would apply against me also.
No, but yes, you have to show that the document, because
Connection.
in that case there was no connection.
There was no, but here there is connection. That is exactly why I have prepared pointer-wise note, my lord, just to pinpoint the document to join the conduit, my lord. Your lordship would kindly permit me to hand this up, my lord. Your lordship. Other side copy. No. Paper number 10. Now, your lordship would kindly see my lord's order dated 16th September 2025, where, my lord, the injunction against the defendant number 6 was vacated. Because I need to, my lord, show this to your lordship and then, my lord, try and persuade your lordship to hold
16 September.
16 September. My lord, copy acha?
Yes.
Has your lordship got it, my lord? My lord, kindly, my lord, comes to page 14, paragraph 29. I shall show your lordship the reasoning portion of my lord from paragraph 29 on. After, my lord, quote, recording the submissions of the respective parties.
Yes.
29. In the present case, all the contracts were entered into between the plaintiff and the defendant number 1. There is no document to show that contracts entered into between the plaintiff and the defendant number 1 is binding upon the defendant number 6. The payments were also not made by the plaintiff to the defendant number 6. Thus, the judgments relied upon by the plaintiff are distinguishable from the facts and circumstances. So, this is one observation. Then, paragraph 30. The plaintiff has relied upon photographs taken in course of the packing of the plaintiff's bags at the factory of the defendant number 6. It is not denied that the defendant number 6 is a manufacturer and supplier to several customers and buyers. Mere appearing of the logo of the plaintiff company in the said bags cannot prove that the defendant number 6 is having any contract as claimed by the plaintiff. This is the second observation. Then on paragraph 31, the plaintiff has also tried to correlate the contracts between the plaintiff and the defendant number 6 by referring to HS code in the purchase order and the tax invoices with respect to the material supplied by the defendant number 6 to the defendant number 1. In the affidavit in opposition filed by the defendant numbers 1, 2, 3, and 5 in paragraph 16 has categorically made an averment that the defendant number 1 paid rupees such and such towards reimbursement of the material purchase from defendant number 6. Really, well, paragraph 32 then finally. On the next page. Taking into consideration of the above facts and circumstances, this court finds that the plaintiff has not, this is the first, has not disclosed any document to establish that the defendant number 6 assured the plaintiff to supply goods through the defendant number 1 first. Second is the plaintiff has not disclosed any document or any amount is pending with the defendant number 6 and the defendant number 6 has not supplied goods to the plaintiff. 2. Then in contrary, the defendant numbers 1, 2, 3, and 5 in their affidavit categories stated that the amount which the defendant number 1 has paid to the defendant number 6, the defendant number 6 has supplied goods to the defendant number 1, and the defendant number 1 has supplied to the plaintiff. The defendant number 1 has also denied that the defendant number 1 has paid advance amount of rupees such and such to the defendant number 6 for purchasing goods. So I need to know if I can show anything beyond this. Yes. So my notes is only restricted to things beyond.
That's why the party.
Everything else was there in my previous note file.
If the other parties proves that yes, these are the transactions, these are content.
Yes.
Different.
Now, Manoj, kindly sees that. Manoj, this in paragraph 1 of my note. I shall be very brief, Manoj. In paragraph 1 of the note, I had mentioned what all findings are there in respect of the defendant number 6 in this order. Then kindly sees paragraph number 2. Just because the injunction against defendant number 6 was vacated, it cannot mean that the same should be vacated against the defendant number 10, in as much as the defendant number 10 stands on a completely different factual footing. Now, kindly sees what is the factual.
This is only in respect of defendant number 10, as of now. Okay. 11 and 12. Give me the notes.
10 is not there, Malad. Malad, kindly sees Malad the next way.
10, 11, and 12 stand on complete different footing. The facts pertaining to 10 are different.
Malad, kindly sees defendant number 10's affidavit in opposition. Ekটু jot করতে হবে. Defendant number 10. একটা ডিফেন্ড নাম্বার 1 একটা দেবেন আর 10 একটা এও আর ওদের এআর গুলো ডিফেন্ড নাম্বার 1 এর এআর in matters like this, the liquid text really helps because everything is there in one click. Your lordship can.
Many high courts have also now adopted the paperless brief model. Many high courts, this system, the internal high court system already had paperless brief system as far back as 2020 in Delhi High Court. So that is much easier to navigate.
I went before. Problem is not with regard to the adoption. Problem is
infrastructure. Infrastructure.
Absolutely. You get that.
That is true.
We'll kindly have a look at
opened a new section dedicated to the commercial division.
One of my juniors went to Hyderabad. Delhi is one of the premier courts, but went to Hyderabad. There are 14 commercial courts. 14 rooms in the commercial court, 14 different courts. Kindly sees page 95 of the affidavit in opposition of the defendant number 10. And in their affidavit, the defendant number 10 discloses a seizure list. Your lordship would find towards the middle of the page, there is particulars of articles seized. Kindly sees there are 6 container numbers mentioned there. 6 containers. Your lordship would find the container numbers mentioned there. Kindly compares this with page 326 of my petition, because at that point of time, third volume, at that point of time, I did not have the defendant's case because we had moved it ex parte. So we knew nothing. Kindly sees in my petition what all. Kindly sees page 326, my lord. I'm sorry, my lord. Yes, my lord. Interlocutory application of the plaintiff. Volume 3. 326, my lord, will find is a invoice raised by Simora Cargotech. That is the container liner. Kindly sees the number of the containers. This is a bill raised on me for the containers. Kindly, your lordship will find the container line numbers match. But I've indicated that in paragraph 2 of this note. Now, kindly also notes on the right hand side of page 326, there is an entry POL, which is place of loading. Kindly marks Shamfero, defendant number 10. On the right hand side of page 326. Invoice date, due date, then POL. On the right side top. Here, on the right side top, POL is the place of loading. I had indicated that in paragraph 2, Shamfero. So this is everything before the defense case comes. Now, my lord, so your lordship would see that the containers seized from defendant's factory are the containers which I have, my lord, taken on rent from Simora, where the place of loading of the containers is Shamfero. So this line, page 95. At the defendant number's factory, defendant number 10's factory. Kindly comes to page 95 once, my lord. Yes, inside factory of Shamfero. Shamfero is 10. They have disclosed this, my lord, with their affidavit. Same containers, plaintiff's containers gone there. Yes, yes. Now, my lord, kindly see point 3 of my note. SGS. Mr. Rudraman Bhattacharya was appearing. Mr. Rudraman Bhattacharya was appearing. And kindly see small Roman 3. SGS was appointed by the plaintiff to inspect, draw samples, and seal the bags. Your lordship would recollect when SGS was appointed. Kindly sees page 267 of GA1. Second volume GA1. I'm sorry, my lord. This is in third volume. I'm sorry, my lord. This is in the same volume. Kindly pardon me, my lord. It's the same volume. 267. But if your lordship so desires, my lord, we can give a convenience compilation with this note with only these page numbers. Only these page numbers annexed. In course of today, my lord, we shall give it. Only 4 pages annexed. Page 267 kindly sees, this is, my lord, an email from SGS written to the plaintiff. Copy mark to other officers of SGS. Kindly sees what is the content, my lord. So SGS is being appointed to carry out the inspection. Appointed by the plaintiff. Kindly sees at the top, my lord, the heading of the email. Inspection of 540 MT of medium carbon ferromanganese. This is very important because the entire plaint case, before any defense came, is I have sourced medium carbon ferro only from this defendant. There is no other defendant from which I have sourced medium carbon ferro. And your lordship would find quantity is 540. Now, my lord, kindly turns over the note. I have mentioned that I have not sourced this material from anybody else in paragraph 3. Kindly turns over to my lord small Roman 4 at page 3. The defendant number 10 in its affidavit have disclosed documents having sold exact 540 MT of this particular item, medium carbon ferromanganese. Where your lordship would find it, kindly see page 61, my lord, of the affidavit in opposition. I shall show 4-5 pages from this affidavit in opposition, my lord. Page 61, your lordship would find towards the middle of the page, email dated 21st February 2021. Kindly sees the fifth line of our shipment of 540 MT of medium carbon ferromanganese. Now, towards the middle of the page, yes, 540 MT of medium carbon ferro. This is one. Then kindly turns over to page 64. If you do not leave 540 MT, then we will give to other party. So the discussion is with regard to this 540 MT. Same thing your lordship will find. Your lordship will, it's note, I am not taking your lordship with that. To that, 64, 65, 66, 68, same emails. Your lordship need not be bothered. Kindly now comes to page 91 of this affidavit of defendant number 10. 91, my lord. This is a ledger disclosed by the defendant number 10. Now your lordship would find entries dated, the third entry of that page, 27 February 2021. There are 10 entries of that date, going up to the penultimate entry of that page. All your lordship would find is medium carbon ferromanganese. And your lordship would find that this is between Apocalypse, the defendant number 1, because that's the ledger heading, and the defendant number 10. So I'm only trying to join the conduit, my lord, which your lordship found missing so far as defendant number 6 is concerned, but I'm trying to join that conduit. So here, this goes on to, my lord, page 95, where it has been recorded what all have been sold and what payments have been received. Kindly see page 92, my lord, last 4-5 entries are the payments received. 1st of March, 4th of March, 10th of March. These are payments received through Apocalypse. 91 is, my lord, this is the ledger which shows the goods sold and the payments received. So 91, your lordship would find the heading is sale. Kindly see the 4th column, type, heading is sale. So, my lord, 27th of February, there are 10 entries which shows the sale. Sale is of medium carbon ferromanganese. The next column, my lord, particulars, kindly marks, my lord, sale of MC ferromanganese. So all these are MC ferromanganese. My lord, all the entries dated 27th of February 2021. As your lordship got it, MC ferromanganese. Then my lord will kindly turn to, my lord, yes, yes. Serial number 3, going up to, my lord, the next page. So this shows that all these goods have been sold to defendant number 1 because that is the main defendant, defendant number 1, through whom the entire transaction has been routed. Now, my lord, your lordship would kindly turn to, my lord, page 92 and see there are bank transactions referring to receipt of payments. Which is dated 1st March 2021 onwards. 1st March, kindly sees all these have been received from Apocalypse. This goes on to the 10th of March, 3 entries. Thereafter, then again, there is sales of MC ferromanganese, which goes on to page 93, dated 28th of April. I have included all these in my note. Your Lordship would kindly see the note. Ledger, I have indicated which all items and which all page numbers. Now, my lord, kindly comes to page 99 of this affidavit. In fact, I should start from 97. This is an application filed by my lord, the defendant number 10 before the learned additional chief judicial magistrate at Shialda under section 457 of the my lord, Code of Criminal Procedure. There kindly sees paragraph 99 continuing paragraph 3, which continues from my lord, page 98, kindly sees at page 99. Your Lordship will find in the second, in fact, in the first line, period between 19 February 2021 and 10th March 2021, the applicant company made a total dispatch of 540 MT of medium carbon ferromanganese, valuing rupees such and such. Against the purchase order ASPL. I shall show the purchase orders later. So this is, they have admitted in that. Now we'll kindly have a look at my petition, page 61, GA1. GA1, page 61. I have referred that in paragraph 5 of my note. Paragraph 101 at page 61. So this refers to all these 6 containers which have been found with the aggregate quantity of 162 metric ton. So this is before anything, any defense comes, my lord. Now, my lord, I'm sorry, my lord, I'm having to take your lordship to comparing the two stands, my lord. This 162 MT, which your lordship would find pleaded in paragraph 101, is corroborated from the defendant number 10 stand also. That your lordship would find at page 80 of the defendant number 10's affidavit. I've included that in paragraph 5 of my note. Kindly comes to my lord, page 81, my lord. This is an email dated 14th of June 2021. Kindly sees the first line, our repeated follow-ups and several reminders for the balance payment of 162 MT. Exact. What my petition case is, they come up with a defense corroborating my petition case. But if there was no contract, then I could not have given exact figures, exact container numbers, exact metric tons. Then kindly also, my lord, apropos this, comes to page 102. 102 of this affidavit, my lord, of the defendant number 10. Kindly comes to paragraph 7. 102, this is that application before the judicial magistrate, my lord. Paragraph 7, my lord, will find seizure of 162 MC ferromanganese. Again mentioned. So same quantum, your lordship, quantity your lordship would find. Now, my lord, all important. The shipping bills. These shipping bills have been prepared by the defendant number 1 and disclosed with defendant number 1's affidavit. To defendant number 1 affidavit. Ew. Kindly comes to my lord, page 94. So, my lord, they portray I am nobody. They do not even know me. Excise documents would prove otherwise. Page 94, your lordship would find But I'm sorry, it starts from really page 91. Yes. I'm sorry, there's a page number error in my note. Instead of 94, it should be 91. Yes, in the note. It starts from 91. I'm 94, it should be 91 onwards, my lord. It should be 91 onwards. Yes, my lord. Kindly pardon, sir. No. Not here, your lordship would find on the left. On the left, there is the name of the exporter, Apocalypse Steel and Power. Now, under the heading B, declarant details. Has your lordship got here? Declarant details. Here is the Apocalypse Steel. And on the exactly on the other side, my lord, of that, on the right hand side, your lordship would find consignee name plaintiff. Do a thing. Your lordship would kindly then skip a few rows and see invoice number ASPL 58 of 2021. Kindly marks this invoice number. Then apropos this document, the customs document, kindly turns over to the next page, 92, where your lordship would find the commodity, the last entry, MC ferromanganese. Now kindly turns over to 94. Importantly, here your lordship would find name of Sham Ferro there. At the bottom, kindly see 6 division Sham Ferro Limited. So shipping bills of defendant number 1 shows consignee name as the plaintiff and the seller to be Sham Ferro. Kindly, my lord, then turns to page 100. 97 है देखिए दिलाम तो ठीक है kindly comes to page 100, my lord. Your lordship would again file the name of the defendant number 10 at the bottom, my lord. Page 100, my lord. Yes. Your lordship would find Sham Ferro alloys. Then, my lord, will kindly turn to page 106. Same thing, my lord. And 107 also, same thing. So, my lord, the own showing of the defendant number 1 shows the interstate transaction between 3 parties, which has been denied. Defendant say, they do not know me. Now, my lord, kindly sees. Now, my lord, kindly now take defendant number 10's affidavit. This I was showing from defendant number 1. Kindly sees, my lord, the note, paragraph B, and my lord kindly takes up defendant number 10's affidavit in opposition. In his affidavit in opposition, the defendant number 10, and this is, my lord, a case which I am trying to show the falsity in the case. The first heading of my note is to show the connection. Heading B is to show that the purchase order, there's invoices have been inflated, emails have been fabricated. And why I say so, my lord, your lordship would kindly have a look at, my lord. But this, my lord, really baffles us, but I'll try and satisfy, my lord, your lordship, that whatever has been stated could not have been. I'll try and satisfy. Only two documents I shall trouble your lordship with. But possibly some date change or something they have done. I do not know, my lord, what all happens these days, my lord, but I'll try in my own way, my lord, to try and satisfy lordship on that. Kindly takes page 58. This page 58 is, my lord, a document disclosed by the defendant number 10 with its affidavit. This document is the invoice placed by the defendant number 10, defendant 1 on 10. So, my lord, Apocalypse is defendant number 1, placing this invoice on, my lord, Shamfair. Kindly sees what is the price. Quantity is 1000 metric ton. Price your lordship would find 140,000 per metric ton. So this is total is, my lord, 14 crore. Importantly, my lord, though, my lord, your lordship has frowned upon only the bags, but kindly also sees, my lord, now that I am trying to join the conduit, the comments on special instruction, there is a box. Kindly sees the fifth entry, packing 1 metric ton jumbo bag. Kindly sees the last 2 entries, third party inspection to be done by SGS. I have shown emails of SGS 540 metric ton. 4th, jumbo bags to be provided by us. So this again, my lord, corroborates the plaint case. Now, my lord, your lordship would find that this document, this purchase order, shows that defendant number 1 is purchasing at, my lord, 1,40,000 per metric ton. Now sees what is the contract I have placed on the defendant number 1. That your lordship would find at page 48 of my affidavit in reply to defendant number 1's affidavit in opposition. I am paying him 1,02,000 per metric ton. So he is in 999. Kindly see page 48 of my affidavit in reply, my lord. Your lordship would find, and kindly also marks the invoice number, my lord, ASPL 058. That your lordship would find in the shipping bill. Now your lordship would find the quantity, the rate is 999 euro per metric ton. The penultimate column, my lord, of that page, the second last column, euro rate is 999 per metric ton. Now on the prevailing rate, this was calculated as per the prevailing rate, which I have pleaded in paragraph 8 of this affidavit at page 10. No. Paragraph 8 at page. No, my lord, it's not there in the reply. I'll take your lordship to that, my lord. Kindly skips that, my lord. Then, my lord, invoice is shown. Paragraph D10's reply. In paragraph 8 of it to plaintiff reply to defendant number 10 affidavit in plaintiff affidavit in reply, Rajesh Upadhyay Dakshit order to affidavit in opposition of defendant number 10. This is why I was proposing a convenience compilation. I'll append to the note, my lord, all the relevant pages, my lord, only. Paragraph 8, my lord, your lordship would find at page 8, my lord. There's mistake. My lord, it should be page 8, paragraph 8, my lord. Yes. But I have calculated euro. At that point of time, it was rupees 86.65. And my lord, this also is there in page 10, that it's coming to 102 rupees per metric ton. So, my lord, this is the index rate, my lord, which is there. So, my lord, what is the transaction? I place a purchase order on the defendant number 1 to purchase at rupees 102 per metric ton. The defendant number 1 is placing a purchase order on the defendant number 10 to purchase at 140 per metric ton, which is impossible. This is why my heading of this note this portion of the notice, falsity in the documents. So what they have done is they've inflated the invoices to show that, look, you have given me 100 rupees, I've given you goods worth 100 rupees. Actually, they've given me goods worth 70 rupees. So 30 rupees would have been otherwise pending. This is the fraud. So no prudent businessman would purchase it at a higher rate and sell it to me at a lower rate. My invoices would show, my purchase order would show I am placing it for 1 lakh rupees per metric ton. His invoice, it's an admitted document, he has disclosed, showing that defendant number 1 is purchasing at 140. This is the falsity, my lord. Now, my lord, one other document. Now, my lord, kindly see small Roman 3 at page 5 of my note. Why I say the emails have also been fabricated. My lord, I had indicated, I had shown the purchase order 1000 metric ton. Position is that they have delivered 540 metric ton, 270 plus 270. So balance could have been, my lord, 460. They say at paragraph 4 of my note, at page 64, that email, that, my lord, I have taken 540, yet they are saying, please pick up 540. I have picked up on 19th March. That would be evident from page 99 of the AO, which is, my lord, the document application filed before the magistrate. Between that, such and such date, I have delivered 540. Now, kindly see page 64. 64 of this affidavit. No, of the defendant number 10's affidavit, my lord. Opposition. Isn't that a compliance? 64, my lord. Kindly marks the date, 10th April 2021. So, my lord, if he has already sold to me 540, let us take not to me, to defendant number 1, 540. Then out of 1000 placed on him by defendant number 1, how could 540 be remaining, if I could ask this question to myself? On 10th April, they say on 19th March they have sold between February and 19th March. So this is a falsity, my lord. Now, my lord, one other thing, kindly turns over to my note, the last page, page 6, my lord. In my petition, I have mentioned name of a gentleman by the name of Joydev Mojumdar. So I did not know the defense case. I named that person. That your lordship need not be troubled with that. I have indicated that paragraph. GA1, I'll read that for your lordship. Otherwise, I'm having to take your lordship to this another paragraph 65. I'll read that for your lordship. Fifth line of that paragraph. Mr. Ali also met Mr. Joydev Mojumdar, who was introduced as head of marketing. So this is why he was taken to the factory of defendant number 10 at Durgapur. That's how the paragraph starts. Now, if I have made a false case and there is nothing between me and the defendant number 10, kindly see page 60 of defendant number's AO, defendant number 10's affidavit in opposition. Email is by Joydev Mojumdar. Your lordship would find at the top, my lord, Joydev Mojumdar, 18th February email, next 20th February email. Then, my lord, page 61, again Joydev Mojumdar, copy marked. So, my lord, your lordship would kindly see the conclusion of my note. Unlike the defendant number 6, this is not merely a logo on a bag. We have documents to show that there are identified containers SGS inspection and sealing is there. There are identified goods. The actual seizure of the plaintiff goods from the defendant number 10's factory. The shipping bills have the name of the plaintiff as the buyer, the defendant number 1 as the exporter, defendant number 10 as the entity from whom the goods have been sourced. The exact container number of the containers for which the container liner billed the plaintiff. So all these documents are there for the defendant number 10. So, my lord, it is my humble submission, subject to my lord's kind consideration, that your lordship would kindly continue the injunction order against the defendant number 10 also.
Mr. Gupta will also have to address insofar as the 11 and 12 are
But
concerned.
insofar as the other defendants are concerned, could I come back on other day, my lord? I'll finish all in one go, my lord, because these are the two main defendants.
I'm appearing for defendant number 8, 9 and 13, 14. Now, we had taken out a vacating application. But our case, my lord, I'll take 5 minutes to the clock for each. My lord, our case is that the defendant number 1 to 10 had failed. Thereafter, he had come to defendant number 3 and 4. My lord has already held that if there was no contract between the defendant number plaintiff and the defendant number 6. So for me to come into the scheme of the things, my lord, that first thing had to be that the contract between the plaintiff and the 6 had to survive. If there is no survival, my lord, because specific case, there is a failure by the defendant number 1 and 10 to supply, therefore there has come to me. So my lord has already held that there is no contract or no contract between the plaintiff and the defendant number 6. So my entry to the scheme of the things, my lord, is itself a questionable. GA 11 and 12.
Lord, kindly permits us to give the convenience compilation by tomorrow morning, my lord. We shall.
But my applications may come, it's not appearing in the list. 11 and 12 giving. My lord.
Final hearings.
No, let them address. Let him address about 11 and 12.
No, all the defendants actually. Yes.
No, if it appears in the list with this matter, my lord, it is not in the list. GA 11 and GA 12.
So let the GA 1 hearing be.
My lord, but that is connected. If the GA, my lord, whatever I say. Then we have to take our steps.
Yes. Because we had not filed separate vacating application. It was on affidavit.
Affidavits.
My
On
lord,
affidavits in GA1.
My lord, it has to come before my lord
Because despite your lordship's order, they have not filed their affidavit. That is why they come up with an application.
So everybody who had filed affidavit, that has come before your
But
lordship.
we have to ask because my survival is dependent on the GA1's result. But we have to ask it. But if my lord records my submission to that effect. The comparison that you put up. One 8, 9 and 13 and 14. 14. But two separate GA 11 and GA 12. 5.
But the interim order is still today, my lord. Interim order extended till 30.